Good morning. Today is Thursday, December 15th, 2016. The hearing board is in session. We're meeting in the hearing room at the SCAQMD headquarters in Diamond Bar. Time is 9:20 a.m. We have two matters today. SCAQMD versus Browning Ferris Industries of California and Republic Services, Inc., doing business as Sunshine Canyon Landfill, case 3448-14. We have a pre-hearing teleconference at 10:30 this morning, and then at 1 p.m. we have another matter, SCAQMD versus Aircraft Heat Treating Company, Inc., Anaplex Corporation, and DOE's 1 through 100, case 6066-1. That's a group order for abatement petition. So we'll take the matter up, the continued matter in SCAQMD versus Browning Ferris, Republic Services, and Sunshine Canyon. Who's representing the executive officer this morning?
Good morning, board members. Nicholas Sanchez and Karen Manwaring on behalf of the executive officer.
Thank you. Representing the respondent?
Good morning, board members. Tom Bruin for respondent.
Thank you. Don't expect any testimony, but those who will be testifying, please rise to be sworn in. Anybody? Nope. Okay. Board members, we have now spent about 16 days, I think. Mr. Sanchez, did you wish to address the board?
Just only to relay that I did forward the clerk the updated order for abatement with the track version that was also distributed to the community via email yesterday upon me emailing to the board. So I hope the board members receive those two documents. And as the chairman did last time, I would ask that just the new document be inserted into Exhibit 36, Tab 1 as the most recent proposed findings stipulated to by the parties.
Okay, I think our process presented a little bit of a problem to the clerk of the board in keeping track of which document was which. But I think because this one is date stamped, that shouldn't be a problem. Am I correct? Correct. Okay. All right. So we have revised proposed findings and decision that is date stamped December 15th, 2016. We're going to mark that as the next exhibit in order. Madam Clerk, while she's looking that up, the board appreciates having had the opportunity to take a look at the documents last night. I did receive them. I don't know if the other board members did. I see a lot of nodding heads, so I guess they did. And the proposed findings and decision date stamped December 15th, 2016 will be marked as exhibit number 40.
The only addition I would make is my colleague spotted on page 2 of that document, line 2, I didn't add the last two hearing dates. So when I said this petition for stipulated order for abatement was heard, I list the August, October, November, and December dates. It only lists through December 8th, so December 13th and 15th should also be added. But everything else should be fine as stipulated by the parties.
Thank you. Mr. Bruin, did you have anything before we begin our deliberation?
No, sir. The stipulation is acceptable to respondent.
Thank you very much. Okay, as I've said before, the ball's now in our court to deliberate. As I indicated, have heard a lot of testimony, seen a lot of paper, heard a lot of members of the public tell us about their experiences, and have received proposed findings and decision which have been modified a couple of times based on testimony that we've heard, based on questions by the board, and I think we're ready to deliberate. I would ask this of you, how you want to approach this, and that is, we can go paragraph by paragraph and get a consensus or questions or comments or discussion, and then go on to the next one, or we can take it as a whole based on the fact that we have had an extraordinary amount of time to review this, and there have been changes, and we've had, I think, some time to look at the changes. Ms. Prusak.
May I suggest, since we do not know the consensus of the board at this point as to whether we want to accept this stipulated order for abatement and what we actually think of the stipulated order for abatement, that we at least first begin with a broader discussion. And then if it comes to the point where it seems we might reach consensus, then to go through paragraph by paragraph.
Okay, there's one word I didn't hear, that we go through.
I'm sorry. If we reach consensus that we go through, then at that point, line by line, or paragraph by paragraph, or section by section.
Okay. Who would like to start off the deliberation? Ms. Bird.
I'm always willing to start. I think that after hearing all of the testimony, it still came down to the basic three things that the district stated at the very beginning, and that was, and which is also included in the proposed findings, and that's that the odors are a result of insufficient gas collection, inadequate treatment of incoming daily waste, and inadequate daily and intermediate cover procedures. And as I went through last night and this morning, I could see in different conditions that the district had addressed how to handle those three particular categories of items. Also, in the in the findings, there were references to what the experts concluded, and which had to do with the intermediate cover and the alternative daily cover and investigation of gas migration. And as I went through the petition, I could see that items had also been addressed by conditions within the petition for those as well. I think that for me, after hearing all the expert testimony, that what is before us is a starting point, and I think it's a very good starting point. I recognize that it will be something that has to be monitored, and that we always have the option of having a callback whenever the board comes to a point where they don't think things are moving in the direction that they need to, as well as whenever there is concern from the public, and we can take that into consideration and have a callback. But as the petition stands, not the petition, I've read this a million times. My eyes won't focus anymore, I've been reading so much. But as the findings and decisions and the orders stand now, I do believe that it's a good starting point. I do believe that there are conditions that address inadequate gas collection and treatment, some of which have to do with the timing of when trash will be allowed to be received at the facility. Some of it has to do with the continuation of using the alternative daily cover, as well as adding soil in certain areas that have been determined to be high sources of surface emissions, to have high sources of surface emissions. And I think that will be the start. One of the things that sticks with me is the district's witness, and he believed, and I would have to put credence in him because he's there all the time, but he believes that with the conditions that were set forth, that there should be some change seen in the next approximately 3 months. And that was significant to me, that it may be noticeable within the next 2 to 3 months. That was what the experts said. So for me, I can accept as a whole what is presented here. There may be some various tweaks that other board members may have or that I may see as we go through the conditions, but I think overall that it addresses the issues that were presented at the very onset of the petition.
Dr. Lerner, did you wish to make a comment?
I have some other comments after we get through this.
Okay, but nothing in general? Okay.
I must say that Ms. Bird's comments are echoed in general by myself, and I don't wish to take up more time by going over them again.
Thank you. Ms. Prusek?
I have general agreement with what Ms. Bird is saying in terms of the fact that I do agree that every area that is of concern at this facility is touched upon in this order. I also do agree with the statement that it is a good starting point. But I do have some disagreement with how, I do not think it goes far enough. And here's how I would frame the situation in my mind. I think it's really important. We have heard so much testimony from this affected community. And it's not the first time we've heard from this community. And it's not the first time we've taken up this matter with this community. This, from what we've heard, and of course we didn't hear the entire case, but from what we heard so far, this is the worst odor nuisance that I have seen in my time on the board. That's based on the number of complaints. That's based on the number of NOVs. I haven't seen that paralleled anywhere else. It's the amount of time that this has been going on. The community has suffered through this for years. We heard the principal of the Van Gogh Elementary School say, this is no longer a nuisance. This is, in her words, an intrusion. That really resonated with me. And we heard person after person saying that it is, in different words, an intrusion in their daily lives, the everyday lives that we all take for granted. And that's just when we talk about what the Van Gogh Elementary School principal says, that's only in regard to the trash smells. Doesn't even take account the landfill gas smells, which seem to permeate the community at all times. Let's keep in mind also, I think it's important, and I started saying this, that this community has already suffered through what I think is a failed order for abatement. This board's first attempt at an order for abatement included studies, other things, but we didn't see the effect that I think we had hoped to see. I was here for part of the amendments of that order, but so I can take some of the blame for that. But we didn't see the relief. And the testimony supports the fact, and the NOVs and the complaint logs, that the situation seems to, in fact, have gotten worse. So I don't think there's any question that I think it is our responsibility to take real, definitive, and most important in my mind, immediate action today. And I don't think the stipulated order for abatement takes us all the way there. It's not enough. Again, it's a starting point, but it's not enough. Not when we could do more and when the testimony and evidence supports doing more. And let me be more specific. There were two areas that I've really zeroed in on. Of course, there's the organics part, but again, almost all of that is taking place in the future, and it is the best response, but it's not immediate. And we can talk about other issues that I have with that. But and then there's the dewatering of wells and that's all good and important. But the two areas that I think really need to be strengthened are, number one, the fresh trash odors in the morning. And there is the delay, but the delay is just not strong enough. And I'll talk about that in a minute, but I think that when we talk about having a start and then using the return to strengthen it, now we've seen that model work. We saw it work, it's been working, it's been working in a case that the two of the attorneys before us are familiar with, and I think it's a good model. But in this case, I think it's more important that we use that return to start stronger for this community and come back while all the other longer-term things are being put into place, and allow Republic, instead of the community, to show us why those things might not be necessary, and we can peel those back because we're seeing less odors in the community. So I want to be more conservative towards abating the nuisance, with the return being to prove that those measures are no longer necessary. So to be more specific, I wanted to talk about the morning delay. I don't see that the evidence supports the evidence that we all heard from the expert. I forgot her name, Miss Lee, of the district. With regard to the weather patterns and the wind, and when the wind switches, and what we can see in terms of the complaints, and how that's all tracked. And 8 o'clock is not that time. That time is 9 or after. And we also heard from the principal at Van Gogh Elementary, who said that historically, 9 o'clock seemed to be the cutoff for her and the school for when they were experiencing odors, but recently she was seeing them creep past 9 o'clock. So we're talking about, yes, maybe there's some delay. If you delay the opening until 8, maybe 8:30 you'd start seeing odors. But I don't know why we would stop there. I do not know why we would stop there. I think we should ask the parties to make the delay 9 o'clock for all trash, not just the transfer trucks, not just Republic's trucks, but for all of the trucks, until we see a real change in this community. We also heard from Mr. Sang that the City of LA trucks, which would only be delayed till 8, are largely residential and have large amounts of organics, immediate organics diversion. So, and we heard some statements that, well, we don't know unintended consequences of what's going to happen with that trash. However, we didn't hear any evidence that there's a problem with diverting that trash. And what we did hear a lot of evidence about is that this particular landfill is not working properly. And this particular landfill, at those hours of the morning, have wind patterns that really affect the community. And so what I heard is that in order to help abate the nuisance, we need to move that delay. I also would argue, but we can get into it, that I don't think we should start with the adverse weather protocol. I think that has a lot of variables in it. I think that we've seen testimony that wind speed changes in the neighborhood, it slows down. We heard testimony from people in the community that it gets stuck in various places in their community. And so I'm not sure that adverse protocol and wind speed and all of that and direction, and also we heard from the experts that the wind direction could change on a dime. So that could happen any time in the day, but that's my feeling, that needs to be strengthened. And also, when we can get into it, the intermediate cover, when we get into the specifics of it. But I think that the overall approach is a good one, but not going nearly far enough. And I think that the emphasis needs to be changed to protect the public, and with the return being to have to prove that those measures are no longer necessary. And I also might argue one last thing overall that isn't included in this. Perhaps not a reduction in tonnage, except for that which would naturally occur from the delay from 9,000 to 6,000. But I think maybe we need a cap, because we were hearing testimony that there are plans to increase the amount of tonnage and contracts to increase the amount of tonnage. And until these measures are in place and we see them working, I do not think tonnage should be increased at this facility. So those are my overall feelings.
Before I go, Senator, did you wish to make a comment?
Now, I had just one concern with what Ms. Prusak was asking and whether or not she had a suggestion as to how to approach it. My understanding of the whole situation is that the district has talked with the city of LA. The city of LA and came to this agreement that they would start at 8 o'clock. This is a very, very touchy situation because the city of Los Angeles, county of Los Angeles, basically are the ones who are giving the facility their CUP, and they're the ones who dictate what will basically be allowed there. But at the same time, we would like for the city of LA, county of LA, to delay their deliveries. And I wasn't party to the discussion of the district, but I would imagine that puts some restriction on what can be, on a change in time. If the city of LA, county of LA, whoever it is who is dictating when this trash will be delivered, when it will be delivered. And I guess I didn't specifically ask that question of the district council, but I heard in their discussion and there's some of their replies to why this happened was that they had discussed it with LA. So while they can maybe dictate Republic's trucks not coming, and Republicans say that their trucks won't come at a certain time, to say that LA won't have any trucks coming, and that I don't know how that can occur based on the situation with how the landfill is managed and the fact that it's managed by the city, county.
I did, what, oh, if so.
Well, if you want to answer her, then I've got some
No,
comments.
okay, I'm sorry, would you?
No, do you want to
Okay.
answer?
Yeah, I heard that throughout this, that the district's intention was to continue to keep all of the various other agencies in the loop, to talk with them about how they felt about the particular stipulated order for abatement that was adopted. But we are the only agency with any ability to abate this nuisance. I mean, we're the ones. We're the ones. We've heard the LEA deferring to this agency in terms of air quality, and I haven't heard anything that says it's impossible that the city of LA can't reconfigure how it's sending its trash based on our decision that this nuisance cannot be suffered through any longer by the people of this community to this degree. And so I haven't heard anything that says that's impossible. In fact, well, I know that the traffic study needs to be done first. And also, so that's in there, and I agree that needs to be in there before any delay occurs, aside from Republic's trucks, which have already been for some time being delayed. But I don't see any barrier to that, and in fact, the district had originally asked for a reduction of 3,000 tons. That's a lot more than the few hundred tons that potentially will either be completely diverted or just delayed during the week and during each day. And so I did not hear evidence that there is an absolute barrier that cannot be worked around by the city of LA should we determine that this is necessary in order to sufficiently abate this nuisance, and to see whether we could do that. Also, and I'm a little bit fuzzy on this testimony, but Republic's witnesses were testifying as to the adverse weather protocol that's been in effect for a few months, and It's unclear because in the testimony, I heard that the trucks were all delayed until 9, and I assume that included the City of LA trucks, so that they were already being diverted. But at least in the handouts that were given, it was 8:30. So it was either 8:30 or 9. It was definitely past 8 o'clock. So we should look back on that and see if the City of LA was included in that, but I think it's already been done.
Okay. Before we get deeper into detail, a couple of my fellow board members sat in on the hearings we had some time ago, wherein we issued an order for abatement to alleviate the problem that the community is experiencing and has been experiencing for too long a time. Based on the information we had at that time, we were convinced that there would be a reduction in the frequency and intensity of the odors. It didn't happen. And so the problem continued. And if we look back, starting 2013, and only starting because that was an agreement as far as between the parties as to when the number of notices of violation and complaints would be counted. But okay, let's start counting late 2013. Over 3,000 complaints, over 90 notices of violation, starting in 2013. And here we are in 2016 with the first hearing on the matter on October 27th. 3 years. Let's look at the order. First sentence in the conclusion says, the order set forth hereinafter is likely to mitigate. And that's true. It's likely to mitigate. Second sentence says the order is intended to help reduce. Doesn't say it will. And it ends up by saying that the order is intended to help reduce air emissions impacts to the nearby community, implement steps to reduce any public health impacts that may exist, and alleviate odors while a more permanent solution is achieved. Okay. I think this goes a long way, this proposed order goes a long way to reducing odors. But I too have a couple of concerns. With respect to the trash odor, Ms. Prusak discussed, I'm dubious about how well the adverse weather program will work, and the reason is it relies on weather reports, or weather forecasts rather, which are very good in some areas. But in an area with topography such as we have in the Sunshine Canyon landfill area, it is unpredictable. There's mountains, there's paths, there's that canyon. The wind goes every which way. And so it's I would not rely on it for something of substantial importance. With respect to the City of Los Angeles and the 8 o'clock time, I think, first of all, that the change in hours should be year-round, primarily because of my doubt about the weather program. With respect to including the City of Los Angeles in the later time, I don't know. Ms. Prusak has raised a number of issues, and perhaps the best way to go about this is to adopt now what we all can be comfortable with based on the evidence we've heard, and set another hearing in a very short while to get any further information on those issues, such as the ones that Ms. Prusak has raised. Because I think some of us feel that maybe there's not enough evidence, we haven't heard enough to convince us that taking those additional steps beyond the order will not get us into some problems that we don't know about. The proposed order is the result of a lot of discussion between experts, some agreements between 7 different government agencies. And so surely there's some areas where some compromise was made that maybe can be tweaked a bit. But I'm for moving forward now, and for those areas that we have still some concern, revisiting them in a very short period of time. Ms. Prusak.
I'm sorry, I wanted to point out that I was looking furiously through my notes, and I saw that on the 29th of November, Mr. Hauser for Republic testified regarding the adverse weather protocol that they currently had in place. His testimony was that it was deferred until, the opening was delayed until 9 o'clock. That included city trucks, which is the second largest source. And his specific testimony was some return and some are diverted. So, and he then went into that they are already reducing tonnage in this way at the landfill, and he estimated 300 to 400 tons per day. So I just want to point out that the evidence clearly shows that if we order it, it will happen.
The diversion, on a continuing basis, we don't know to what extent, nor what the impact will be elsewhere. And I think we need to know that.
The only thing that, I hear what you're saying, Ms. Prusak, and I guess I don't want things to be delayed because we don't have all the information as far as a start or delay of accepting trash. I don't want the order to be delayed. The only thing I can think of is there is a provision in the order that addresses when there's a conflict of agencies that something has to be brought back to us. And if we put in the order a delay of 9 until 9, and that is a conflict, then that will come back. That's all I can conclude that could happen there. I just know that it would be kind of difficult for if you had a business and someone was offering you the permit to conduct your business, to tell them that, no, I won't take your business. And you know what I'm saying? So I'm just trying to make sure that it's even possible. But what we put in the order, if there's a conflict with agencies, that will be addressed by the order. I think it's in general conditions where it may speak to that. Yeah, that it doesn't, it says on page 20 that the conditions in this order well, I'm reading the red line, so I'm not sure what page it is, but it's the next to the last page. And it's General Condition 1, the second part. Conditions in this order shall not in any way restrict or expand the scope of jurisdiction of any agency. And if any agency shares jurisdiction that requires the respondent to take action that is inconsistent, then the respondent has to immediately contact the district. So the best possible scenario, I guess, would be to put a delay in, and if it's a conflict and it cannot happen, then it will be brought to the district, and we will be aware of it.
Senator?
For those who are watching, I just have a little headache and so on, and I'm sorry about that, but I struggled to get here so I could participate in this process. Having started it, I want
Appreciate
to
that.
finish it. Hold on a second. I always provide, in my mind, best judgment of fair hearing, and I listen to both sides. And I've heard both sides, respondents and the district, and also from the people in the community. And I want to say one other thing, and that is BFIC came before the city council once before. And on the issue of hours of operation, I must admit, I voted from 6 a.m. to 6 p.m. That's responding to the city having closed down Lopez Canyon for continuous violations and imposing hardship and harm on the people who lived in the surrounding area. You can talking about what the city might do in terms of their delivery to the landfill. Let me inform you, the 8 votes will decide what they want to do in the futures they have in the past. The city, in this case, local enforcement agency, is one of the petitioners. They've been complaining. The city councilman from the area, the mayor submitted the letters saying how they are not happy or dissatisfied with the operation of that landfill. If Mr. Bruckner, whom I know very well from Department of Regional Planning of the County of Los Angeles, be assured that they're at the point where they will take the appropriate action to do more than what we're doing here, as they did before, if we don't address the issue and satisfy them that we've taken the proper steps. This is not the first time I've learned that we've had a stipulated order of abatement with this company. And he goes, and the public is very, very upset. They're losing credibility with the agency. They feel very good about the city council and the county because they're down there telling them what the problems are in the city and the council, and the county are responding by making suggestions that we do our job here. This is a very important agency, and we need it in the state of California. We need it in Southern California. They are doing a lot of good here. But there are sometimes we got to let the public know. I know we're saying we listen to the respondents and their experts, and they come up with some ideas. But we got to listen to the public too. And they've had a lot of complaints over a period of years. Now, what do you think they're going to say if we just maintain status quo? And the district appropriately responded to the public because they did, in fact, listen when they made those suggestions, the recommendation in the first abatement order. Not the district, for whatever reason, did they hear anything different that caused them to want to backslide? That's the way the public's going to look at it. Because the public is not satisfied with this approach, piecemeal, over and over again. And the time has come where the appropriate action should be taken to make sure that we're on the right track. Now, if it turns out that the respondent, and I would suggest that they do this, implement these practices, these theories, that's what they are, camouflage, these theories, implement them. If they work, then okay, fine. We can go back and revisit this in 3 months. We can revisit it in 6 months. They can say, look, we've done a good job, and therefore, we suggest you revisit it. These corrections are, in fact, working, which is a good thing if we can do that. But if we do anything less, and then the problems and the complaints continue, as they will, then everybody's not going to look good at all. And I would say that the first proposal, 6 to 9, 3,000 tons. You proposed that you had good cause to do it. The district did. What's changed that caused you to modify or weaken the proposal? So I would just say that no, you did it right the first time. Not that it won't work, but even if it does work, in fairness, we should come back and give Republic an opportunity to say it's working. Now let's tweak this. I will say one other thing that's going to shock you. Maybe disqualify me too. I gave Republic a contract. As chairman of a homeowners association, the board voted for it, and I didn't oppose it. So I'm not against Republic. Okay? I just want you to understand that. I'm in favor of everybody doing the right thing when called upon to do it. Simple as that. And so, no, I'm going to not do anything in opposition to what was originally recommended by the district. And the public will be satisfied with that as a start. Now you can water it down later on if these other things, these weather reports, if they all work, that's fine. I like that. Then you become a good neighbor. For I can tell you this, 8 votes are going to make a difference. 8 votes will make a difference in the future as they have in the past. I don't want to see that to happen because it's kind of drastic. And that's how those guys act sometimes like that. They get tweaked and then they go off. We don't want to push them to do that. And so I don't like these amendments. Unless you can explain to me why you decided to make these amendments, red line stuff, fine, if you can convince me, but I don't think you can.
Senator, I agree with a lot of what you've said, and I will have a question for you. After the order for abatement petition was submitted, there were a lot of meetings between the district experts, experts from the other entities, with city, county, Republic, and in that process, district learned things they did not know before. And that is what I believe led to the changes, which I expect that in their mind are changes which are justified based on the information that they have. I would not call them watered down. I would call them changes based on what, in the view of district staff, is the best way to go. I'll call on you in a moment, Ms. Bruce.
I just want to say I don't, oh, I'm sorry.
I haven't finished. I said I'll call you. No, I will call on you in a moment.
Well, I think you were directing it to me, so let me respond, please.
No, I haven't finished.
Yeah.
I'll go back to what you were talking about the complaints from the public. I agree it's a terrible thing. It is a terrible thing not to be able to invite your friends to a barbecue in your backyard. Not today, but all the time, for years. You buy a home in a nice area, and you open your window at night, go to sleep, and you're woken up by a stench. You have to change the time that you do your outdoor activities. Not today, but all the time. The order for abatement that we heard in the testimony we heard, there was a lot of new information that we hadn't heard last time. In particular, about how landfills work, how they actually work. What happens if you do something that intuitively sounds like a great idea but backfires? And you continue to do that for a considerable period of time, and then you have to go back and correct that? That's a problem. I believe that we should go forward with what we have, that we revisit it in a short period of time, ask for information to help us make a sound judgment on those things, those areas where we differ with this proposal. Alternatively, if we make such a change that this is fact, if one of the parties that have stipulated to this order decide that they can't live with it, and they back out, we are now back to the defense portion of the proceedings that have been interrupted. And that will delay getting the job done. At that point, we will have to demonstrate, or we will have to make a finding that indeed there are violations that of the health and safety code and the rules. I don't think that's going to be a problem, but it's going to take time to give the defense the opportunity that they are entitled to make a proper defense, and that's going to be drawn out. So my feeling is, let's do this now, take the parts that we're uncomfortable with, come back with more information, and then decide if we can go forward.
Thank you, Mr. Chairman. Let me just say that initially, as I said, the district was right on target. What we learned during the discussion, debate, performance has not changed my mind or even the district's mind. The district brought expert witnesses in, really qualified experts, so classified as such, to support the position they presented to this hearing board. They didn't say anything different that would cause me to think that the district was asking for too much to be done. Now, from the other side, their witnesses, some of them didn't even finish college. They had field experience and they were referred to as experts. Their statements were so confusing sometimes, they would never admit where the odor came from. They said from surrounding area. They never said it came from landfill. None of them. And I heard them all, even when I was out of town. I thought that was not good at all. It didn't cause me to believe that they were honest and genuine and sincere, not just to the board, but to the public as well. one guy said, well, it came from the sewer line, manhole. Somebody said it came from surrounding area. None of them, not one of their experts, claim to be experts, but they're not certified as experts. Not one of them is certified as experts, if you recall, based on experience in education and training, because I listened to them very carefully. So I can tell you that, no, this is a good start. I would be encouraged by the respondents if they went ahead and put some of these new techniques in place. I understand the landfill operation, how you get the gas, and so on. So well, we learned that. But they should have known they operate landfills all across, around the country, all over the country. They get a lot of complaints too, by the way. And as Mr. Bruckner said in his letter to the board, that they have a number of landfills operating in the county of Los Angeles where there aren't any complaints. So obviously, the respondents, they know how to get it done right. Sometimes cost is a problem. You got to clear the soil and start all over again during the next day. All that stuff costs money. There are no shortcuts for providing good health practices, reducing odor in the neighborhoods in which these people live.
Ms. Prusai.
Just a few things. First of all, I wanted to point out that the proposed changes that were made from what we heard and from what the district said about it, and also from the testimony that we saw, was an attempt to be more surgical, and an approach to not just take this hatchet and but with all of this, expert testimony, to really understand what the problem is and really try to attack it. And I applaud the effort to do it. I just don't think it goes far enough. And I think that the district has more constraints than we do. And I think when the district sits down with a party and tries to come up with a stipulated order for abatement, they give and they take, and they have to do what they need to do so that there's a stipulation reached. And we don't have that same impediment, and we can go a little bit further. However, I will reiterate what the chairman said, and it's very important that we all realize that today we can only grant or deny the stipulated order for abatement that's before us. We can ask the parties to make changes. If they do not agree, then we will finish the hearing. Of course, it doesn't have to be drawn out and protracted, because we do have the ability to contain the testimony to that which is relevant. However, we did hear at least one member of the public say, I would rather wait a little while longer than have an order in place that isn't going to be as effective as it needs to be. And whether or not the entire community shares that, I definitely feel that way. I also don't agree that the changes that were made were results of just these meeting with the other agencies. And I don't have the impression, I did not hear evidence that agencies said, this is all we're willing to do, and that's why it's in that we're only willing to bless this, this, and this, that's why it's in the order. I understood the order to be what, again, the surgical approach based on experts of, it's important that we delay the hours, and let's try to do it this way, and the intermediate cover is very important, and let's do it that way, rather than the agency saying that's all we're going to allow. And in fact, the testimony does back the changes, well, so far, that I'm advocating for. And again, I'll just go back once again to the fact that it seems that the city trash has already been diverted as a result of the adverse protocol. And the fact that there has been a delayed opening, whether it's 8:30 or 9, not clear, but it is clear based on the testimony that that diversion has happened, and there was no problem with it. I also wanted to just talk about these unintended consequences. And I want to be clear that, yes, we should always worry about the unintended consequences. But I think that we were frightened a little bit more than we should have, because I think that the sterling example that has been given throughout this hearing has been, of the unintended consequences, has been the 9-inch soil, which didn't get peeled back, and now we've got this landfill gas problem. Well, that's sort of like the big horror story, which, yes, you don't want that to happen. You don't want to have problems with, you fix an air quality problem and you cause a water quality problem. But the testimony and the evidence did not support unintended consequences of a delay to 9 o'clock. I didn't see that, and as Ms. Byrd pointed out, there is always the ability of a return should the city say, we just can't do that, even though they've already done it. And the final thing I just wanted to say, something that really I was thinking about the whole time I've been reviewing this order and hearing the testimony on the order, and it is another danger that I think, an unintended consequence that we want to be careful about. I want to adopt a strong order because I want to adopt a strong order, and the strongest one that is supported by the evidence. But I also want to not compromise and adopt the best we can do right now and then come back and make it better, because I heard some evidence about the fact that why is the adverse weather protocol or the delay these months of the year versus those months of the year? And why is it these hours versus those hours? And one of the big things that came back was, well, because those are the hours that the school complaints are coming in. And we do not want to have the consequence where we're adopting something that's halfway there or 3/4 of the way there, but not all the way there. And the result is that the most vociferous people, or the people that are complaining the most, sort of drop off because the odors were delayed or they're not happening when kids are getting out of their cars, but they're still happening in those morning hours because of the wind patterns. And now the community is suffering it, but we're not seeing as many NOVs, we're not seeing as many complaints when we come back for the return. And so as a result, we don't fully fix the problem because we think we fixed the problem, but really what we've done is sort of just fixed it for a big group of people, the school, but not fixed it for everyone. I'm not saying that's going to happen, but that is a big fear of mine as I've read through this. And I want us to keep that in mind if we decide to just okay something that we don't feel will fully address the problem. So I wanted to put that out there.
Ms. Byrd?
I don't want to go back to something that the senator was talking about, but I just wanted to address it. And this is not to support or to support either side, but I did want to say that all landfills are different. And that's based on its geology, the location, sizing, volume of trash. All landfills are different. So one that doesn't have a complaint doesn't mean that things haven't happened, that everything is wrong as far as the management goes. It just might mean that there are some other situations, meteorology, all kinds of things that affect it. And I also wanted to say that I don't know if what would be defined necessarily by the senator as expert witnesses, but one of the gentlemen who was here who published a book. It is the book that is used. I've worked in several different municipalities, and it is the book that is used. It's like the Bible for landfills. So I did want to just say that. I want to go back to the issue of unintended consequences, and I want to move forward with an order. That's my position. I want to move forward with an order. I am willing to adjust that order to the concerns of members of the board as far as hours go, tonnage, and allow for us to receive back, if that is impossible, to receive back the reasons it is impossible and whether or not Los Angeles or whoever provides the holdup is providing the holdup. I know that we'll have to get the parties to agree since it's stipulated and they may not agree, but my position would be to we need to move forward with an order. And we need to make it strong, yes. And if some of the things that have been proposed today will do that, then we need to do that. But I believe the community has suffered long enough, and if we could put something in place, that we need to go ahead and move forward with that and make it as strong as we can as of this time, with the understanding that all the agencies and all the people involved will be up in arms if they can't do it, and they will bring this information back to us, and then we can, as Ms. Prusek said, maybe peel back at that point, but I believe that we need to move forward with the order.
Sure.
Senator?
I agree. I think we should make some changes that is going to be for the good of the community. We can reduce the odors, and we can extract more of the gas, and that's all good. Let me just say that we've been down this road before. We've had abatement orders before us. I was not here, but we did have them. And this, ma'am? Well, same company, same site, same location. And I'm convinced, since I've gotten to know you well, now each and every one of you, that what you did was the best decision you could make under the circumstances, what was offered to you at that time. When you made that decision, you thought I was going to put it to bed. You had no idea it would be coming back tenfold. You think that they were all acting in good faith and that the problem would be solved. But years later, we know it has not been solved. Obviously, somebody didn't act in good faith. I heard during the debate discussion that they kept changing managers. Past 5 years, they must have had at least 4 or 5 managers. How you can get a plan in place and get the employees to implement it and work according to the schedules if the leadership from the top is not there? So it's management also has, can we say something about keep a manager on the job and let him get his job and do it right? You can't say that. That's up to them, to the company. So it takes a lot of spokes in this wheel to make it turn. And I would say, yes, I want to get something done. But I got to tell you, I would not want to see it again. I know I can't say that to make that be the case, but if it's in good faith and everybody doing the right thing, I don't want to see this again. To be very honest with you. Because if we do have to see it again, because somebody then is unhappy. Something that we thought would be done would not haven't been done. And that's a continuing problem. That's not what we're here. We don't want to say that. When we say it's done, it works, we agree with the plan, fine. I think if we were to say, go forth, implement the plan that you're now recommending on the table, and if it works, come back and we can make some adjustments. That's what I think. Yes, I want to vote for something, but I want to make sure that what we're voting for is going to work, because I don't want to be seeing it again with the same complaints. Let the respondents come back and say, we're making this work, revisit this problem. I don't want to see the community come back and say, wait, it's not working. The complaints are still being made to the district. Notice of violations are being written. What have we done then? We just stalled it. And that's not good, not a good image for the district either.
Thank you.
Oh, I'm tired. Thank you, Mr. Chairman.
Yeah, I want to appreciate your being here and not feeling well. That demonstrates your dedication. I am considering Bird's thoughts that we push it out there and have somebody tell us why not. Ms. Prusek, are you prepared to offer something that the board can consider as far as changes?
I'm sorry, I was going to respond to that
Okay.
suggestion. No, because we haven't gone through all of this yet. I'm not exactly sure what is contemplated in having the parties come back and explain why. I don't support it, again, for the reasons of this is the agency. And I have to say, there have been a number of cases where I've sat on this board and we've had told to us that agency isn't going to like this and you have to defer to that agency. And I'm separate that from the unintended consequences because I feel that I've addressed that. But as far as what is this agency's or our board's abilities here, or our reach or our jurisdiction, I have to go back to what I say in a lot of these cases. We are the only place this community is going to come. And we're the only ones who can say, this is as strong as we need it to be. And I don't support bringing in other agencies and saying, well, what do you think you could do about diverting the trash from here? We're the ones who sat through days and days of hearings and saw complaint logs and NOVs, and we saw the numbers and we heard the toll. And we're the ones who heard from experts about how broken the system is at this landfill. The landfill, I'm not interested in how it came to be or whose fault it is at this particular moment. It's broken. And the topography is such, and the wind direction is such, and the wind speed is such, that at certain times there is a nuisance here. We have heard zero evidence that there is a nuisance elsewhere should a few hundred tons be diverted as a result of this. And again, there's ample evidence to show that the city not only can do it, but has done it when faced with an adverse weather protocol and the need to divert that amount of trash. So I would rather see this board adopt, well, again, I have to go back to the fact that this is stipulated, so we have to ask the parties. I don't know that we'll get the answer, but I'd rather see this board adopt the stronger measures to do what our job, our sole job, which is to abate nuisance. That's our sole job. And then if there's some unintended consequences that I have not seen even indicated by any testimony or evidence we've seen, that the provision that Ms. Bird pointed out come into play, and let the parties come and tell us that that has occurred.
I guess I didn't make myself clear, and that's what I was suggesting, that we go that route.
I apologize. Oh, we all, as I babbled on and on.
I also wanted to ask the question. It appears to me that the major concerns are 6 to 9 delay for all vehicles, and that there is a year-round 6 to 9 requirement. Those are the two items that I heard, and I just, but I also wanted to say one more thing as far as the diversion of trash and all that stuff. There's a couple things I think that may not have been, when I say that there might be some restrictions by agencies, the solid waste, I don't know what to call it, framework, regulatory, also has requirements for their integrated waste management plans, and the counties, cities, all of these municipalities have to come up with plans. And so they have plans as to how this will happen. There may be some issue with just saying, okay, it's not going here, then they have to have someplace else for it to go, and there's a plan in place, and that may be something that could hold things up or could change things. I just want to throw that out there because that's a very real issue. My understanding that presently there's only about a third of the trash from LA County that goes to this landfill. So it's already going other places, and that there has to be a plan in place for how to make this happen. But I only see two things that we have thought to change, two major things, I guess I should say, and that's the 6 to 9 and the year-round 6 to 9. And so maybe those are the things that we need to address. But before I even finish with that, there's a conference, there's a teleconference at 10:30?
Yes.
And it's already 10:30.
Okay. Let's take a probably 15-minute recess and reconvene at 10:45, if not later.
Hello, and welcome to the meeting. Please enter your passcode followed by the pound or hash key, and I'll connect you. Please hold while I confirm your passcode. Thank you for joining Global Meet. Please wait for the tone. Then say your name and press the pound or hash key.
Clerk of the Board.
When you hear the tone, you will be the 5th person to join the meeting. Joining the meeting. Clerk of the Board.
We're just waiting for the chair. It'll be just a moment before we get started.
All right. Thank you. Can we call my co-fault or not? I'll take it. Okay.
He's not hearing it anyway.
What's it? No, I said he should just stay there. We're just pretending he's not here.
Good morning. This is a pre-hearing teleconference in the matter of, what's that? of Aircraft Heat Treating Company, Inc. and Anaplex Corporation, and Does 1 to 100 in case 6066-1. Who is representing the executive officer?
William Wong on behalf of the executive officer. I also have Kurt Weiss and Barbara Breard on the line, and our outside counsel, Joe Ibarra from Wang, Ibarra, and Singer is also on the line.
Thank you. I have with me Ms. Julie Prusak, legal member of the board, and also in the room is Senator Nate Holden.
But the senator is not at all, he's just listening because he is not feeling well, and we don't want to move him, but he is not participating in this pre-hearing conference.
Okay, and who's representing Aircraft? Is Aircraft on the line?
Yes, yes, Mr. Chairman, Ivan Tether and Thomas Wood.
Thank you. Anaplex, who's representing Anaplex?
Yes, good morning, Mr. Chair. Ruben Castillon.
Okay. All right. Well, let me begin by asking Mr. Castillon if you've arrived at a stipulation with the district.
I don't know. I know that an email was sent earlier today based on discussions yesterday, but I don't know. I wasn't involved in those discussions. I don't know. I imagine the district is in a better position since they're on the call and they received
Mr. Wong?
Yeah. Yes, we did receive an email from, I think, one of your co-counsel, Haney, I believe. And he indicates that they are interested in a stipulated order for abatement subject to certain conditions. But unfortunately, some of the conditions are inconsistent with the stipulated order for abatement for Aircraft. So, they have made some movement, which is good, but we're not quite all the way there yet.
Okay. So I guess the issue is how do we move forward with a bifurcated hearing where one party has stipulated, the other party is a maybe. Ms. Prusek, do you have any questions on that?
The main question that I had is the mechanism by which, if we're bifurcating, which we did make that motion and voted to bifurcate on the request of Mr. Wong yesterday, and we're hearing Aircraft first, with all hopes that we would finish that today, but not necessarily. What is the mechanism by which the other portion of this case, bless you, that against Anaplex, will similarly move forward in terms of if we continue the hearing, but Anaplex is not present because we're hearing the bifurcated matter of Aircraft. What is the mechanism, and how will we do this logistically is what I'm really looking for, if there's any ideas.
Yes, that's a good question, and I do have some ideas. I think we should proceed on with the Aircraft stipulated order for abatement. We believe that it can be expedited. We'll have witnesses present to explain how effective the order is. But we should also have Anaplex there because we intend, after the board approves the order, to go after Anaplex first, basically on their permit violations, because we think we can address those fairly quickly. We are actually making a request to the hearing board to also perhaps come in on Friday morning to finish up the case against Anaplex. And so when Anaplex is there, it's not like they don't have to do anything. We can actually be working with Anaplex at the same time, basically working out these details of the potential stipulated order for abatement against Anaplex. And if we can conclude hopefully by that day, we can also hear that one. And that should be even faster because, again, it would be very similar to what aircraft is being done. So the board will be well prepped about that. And approving the Anaplex one, assuming it's consistent, and I believe that's what we're going to insist on, will be easy. It will be very easy.
May I speak?
Mr. Chairman, may I speak? This
Yes.
is Ivan Tether from Aircraft.
Mr. Tether?
Thank you. Aircraft is very committed to all of the steps laid out in the stipulated order for abatement, and many have been completed and others are underway. We are not, however, authorized to agree to the order which includes a mandatory shutdown until an order is issued or granted either simultaneously or previously against Anaplex. This is largely because we feel and we understand and have proof that Anaplex emissions affect our monitor number 8. Accordingly, we're very willing to go forward with our case, very willing to accept any kind of interim order that would require us to continue implementing all of the 22 steps that are laid out in the stipulated order for abatement, but we simply cannot get authorization from the management of Aerocraft to be bound to a shutdown that would be triggered by a reading of greater than 1.0 nanograms per cubic meter at monitor 8 until Anaplex is similarly constrained.
And Mr. Chair, may I speak? This
Yes.
is counsel. Let me begin by a whole bunch of issues have been presented right now that I want to make clear is why we filed a motion for continuance. We're hearing this for the first time, not only from counsel, from Aerocraft, but also from with the district in terms of the scheduling that they'd like to have. We have not received documents that relate to the permit. A lot of it's been withheld. The logistics of even defending this case aren't even reasonable from our standpoint. What we went in there yesterday to discuss was whether we could agree on a continuance between the two parties. And in the process, the details of that discussion became more comprehensive, as I understand it. But fundamentally, what I was asking for the court was to continue this to allow us to get the proper documents to be able to defend our clients. So when I hear that it's going to be quick, yeah, it's going to be quick because we don't have hardly anything. I don't want to repeat what I said in our motion yesterday, but I don't want to lose sight that those issues have not been put to rest. The second thing is, with respect to the hearing, I have a personal matter that I cannot escape from. I wasn't going to be able to be there this afternoon no matter what, and I told Mr. Funderberg if it was going to go forward that he would have to step in. So I'm not saying that today wasn't accounted for, but Friday was completely off the table as a date that was a possibility for us. So that's news to me. I know that my reasons for not being able to attend have been communicated to all counsel by Mr. Funderberg. That's what he told me. And if the chair wants to hear him, I'll provide them. But all I can say is it's personal matters, and I'm not changing my schedule. I'm just not, and I don't mean to sound unequivocal about it, but I can't. So from a scheduling standpoint, what I envision, this is bifurcated, and as a practical matter, the complaints have to be separated. I'm hearing Aerocraft reach an agreement that's conditioned on Anaplex. That's the first time I've heard that. And that's actually an improper basis for a stipulation, and it's not in the stipulation. And I'm hearing that, and I haven't even been presented with evidence to object to that or to hear what supposedly connects my client to Monitor 8, which is closer, significantly closer to their property than ours. So now there's a new issue injected, that's been withheld until the last possible moment. And I'm being asked to say, well, it'll be pretty fast and it'll go forward. So to me, the motion for continuance is not only appropriate, but it's absolutely necessary to prevent our client from being prejudiced. I certainly know that if another settlement's conditioned on us, that's inappropriate. We have no relationship to this other company. The case was bifurcated, which to me means effectively there's two separate complaints. In fact, one of the suggestions I was going to make is instead of having the same case number, that we separate the complaints, that they simply draft a new complaint, amend the complaint so that the allegations in those complaints, that complaint only goes to Aniplex. So we don't have this issue about both companies are identified in the same complaint, so we don't hear, this doesn't apply to us, but it applies to them, because there was some of that yesterday. So I think there should be two separate complaints. It should be amended as a practical matter. When the hearing board reconvenes, you set the date, whether it's after our continuance or whether it's after a certain date. That's for the hearing board to decide. But I'm saying that right now I'm hearing a lot of new information, which is actually the basis for saying that our client is going to be prejudiced if this goes forward, given the limited time frame for everything that's transpired up to now.
Mr. Castellon, if we were to do as you suggest, in that to further separate the cases with a separate case number, a new petition, I think we would need to do the noticing, and the clerk is nodding her head, and that would further delay the matters. Ms. Prusak?
Well, I agree with that. However, I do agree with Mr. Castellon in terms of, from the arguments that he seems to be making today, that next time we hear from Aniplex, it needs to be on the motion rather than tabling it. And we need to decide that once and for all, whether there's a continuance granted, how long it would be if there was, and not go back and forth as we are. But I also am concerned that we're hearing for the first time from Mr. Tether that, in fact, the stipulated order for abatement that we are set to consider and possibly grant today actually can't be granted because it's not stipulated to in full. So I'm not sure what we're hearing today. I'm not sure how this is moving forward. And I think as we hear this conversation unravel, I feel we're getting further from understanding how this is proceeding.
This is Ivan Tether. When Mr. Wong initially indicated an openness to a continuance for Aniplex, he stated that that would be conditioned upon Aniplex agreeing to all of the conditions and requirements in the stipulated order for Aerocraft. That seemed to have gotten lost in the testimony on for some time, particularly the testimony with regard to how great Aniplex is. So our position has not changed, but we cannot get our management to agree to be bound to shut down if the monitor immediately adjacent to our facility goes over 1.0 nanograms per cubic meters until we are reassured that Aniplex, and reassured by more than a casual suggestion, that Aniplex will be similarly bound. Thank you.
And Mr. Tether, I'm not suggesting that you should want to be bound by it, but my point is, if that's in the stipulated order for abatement that we are set to consider today, then we won't be able to actually end the matter with Aerocraft, and and that's what I'm suggesting, and I'm trying to understand how this is going to move forward.
Well, that's a very appropriate question. As I mentioned in my initial comment, Aerocraft is willing to put on testimony, and Aerocraft is willing to agree to an interim order that would require it to continue implementing the 22 actions listed in the stipulated order. It's just that we cannot do what I've said we cannot do until action is taken with regard to Anaplex.
And that thing that you said you cannot do, and that is to agree to a shutdown in the event a certain level of Chrome 6 is found in the air. Is that correct? But everything else you would agree?
That is absolutely correct, Mr. Chairman.
Okay. Ms. Prusak, it seems that we should go ahead with the aircraft this afternoon to the extent that we can, and then see what develops after that.
We can, what I'm hearing is we cannot, with finality, dispose of that case. And since we've bifurcated it, I'm not sure where that leaves us, because we've got one aircraft contingent upon Anaplex's decision, but Anaplex is the bifurcated case that comes after aircraft. So I'm gonna, if I could, return the question to Mr. Wong to ask, what is there a proposal by the district of how we should proceed in both these matters? Aside from the fact that I do believe we need to put finality on the request by Anaplex and their motion, and we need to rule on that motion.
For the motion for continuance, is that correct?
That is correct.
Yeah, actually, it's really odd because the email I received today regarding their interest in a stipulated order for abatement did also indicate they were going to withdraw their motion for continuance. So, yeah, that's only for reach agreement. But I think it's important to have Anaplex come to work out the kinks to this, proposal, because we do have some concerns with it. And so they should come and basically be working on that. As with aircraft, my understanding is that we can still go through their proposed, the stipulated order for abatement. The question really is whether the hearing board enters it today or perhaps tomorrow or whatever. So they're agreeable to everything except when the entry of the order takes effect, and that, I think, could be, it's up to the hearing board's discretion as to when they enter the order.
If I may, Chairman, I would suggest, as you just suggested a little while ago, let us hear aircraft today, because it is very important that we move this entire process along as quickly as we can. Let us hear the parties out on that case and what they're requesting us to do. And in the meantime, hopefully, it seems that there has been some headway made between Anaplex and the district with regard to some stipulation, which would then allow for the motion to be taken or to be withdrawn, and for that case to be set in terms of how it will proceed. And if that does not occur, then at the end of the day, we can appropriately determine when to continue to, and perhaps the next step would be, once we've disposed as far as we can dispose of aircraft, to hear the motion from Anaplex if need be. And then everything will start to fall in place from there.
Yeah, we agree with that suggestion.
Mr. Castellon?
I have no problems with, the board proceeding. The issue of concern for me is, let me be clear on this. Mr. Funderburg, along with one of our consultants, has been discussing with the district these conditions and these terms, and that process, unless the district ends it, as far as I know, is ongoing. But I'm not part of it. I'm part of the defense of my client here, and I can't. I'm not doing both. I'm not wearing both hats. I want to be clear about that. And what concerns me from what I heard today, and I do want to repeat it, as far as procedurally, I have no objections to it proceeding as to aircraft, but the concern I have, and I want to reiterate that, is Anaplex has been injected in aircraft's case. And That has never been the case as presented in any way to me would be an issue with the stipulation. And all of a sudden today it's raised. And that is a big deal in the sense that someone saying, I'm going to dump on your client for my client's interest, and I'm going to have no way to defend against that in my case. So I need the discovery. I need whatever's out there to defend my client. And I know I've made the motion for continuance, but this relates to it again as a new issue. And I'm not sure fundamentally if, and I think this point was already made, is how even though you can proceed and deal with some of these issues, ultimately I don't know how you can have a stipulation in order if it's conditioned on another party having something, because it presupposes the other party is going to do something that satisfies another settling party and not the district. So it's empowering another company to decide, well, we think that's acceptable. Now we'll agree to what we've agreed to, which is the number 1 micron. So I conceptually don't understand that. I don't see how that works. And I do think that's an issue because let's assume this is going on in the future. You're still going to have the same argument. Well, we can't agree to the stipulation until we know how it goes with Anaplex. So
if I may briefly respond, the only thing that is linked, because frankly, the stipulated order for abatement for aircraft is independent and doesn't rely upon Anaplex. I mean, there is some concern from aircraft that some of their wind monitor readings might be attributable to Anaplex, but we have taken care of that to everyone's satisfaction in the stipulated order for abatement. The only link, if it is a link, is really the timing of the entry of the order. There's nothing else. And to be arguing that you need discovery for how the two relate to this entry, it doesn't make any sense to me.
Well, it does to me because I've heard a representation.
Just a second.
I'm sorry.
I was thinking along the same lines as Mr. Wong said. The order that the board may issue in aircraft is directed to aircraft. And if there is in that order, well, as Mr. Wong said, it's independent. The order that may be directed to Anaplex would be solely to Anaplex, not depending on what happens outside Anaplex's world. Same for aircraft, not dependent on any other agreement anywhere in the world. Separate orders. And what I'm hearing is Anaplex wants, these orders to be concurrent. Aircraft wants, doesn't want to agree unless they understand that these orders are going to be concurrent. I don't see a problem with entering the two at the same time, other than it's going to put a delay in entering the one for aircraft on a problem that's been, on a problem. Ms. Prusak?
I'm sort of waiting and seeing how this afternoon unfolds as far as delaying the entry of an order. However, I have to say that even if we completely extracted each party and we had separate petitions and separate proceedings, aircraft is free in its defense to raise Anaplex or the 80 other businesses that it feels either one are contributing to the problem, or two will affect its readings at its own meter. It's free to do that, whether the cases are combined or separate, and no, it won't affect the proceeding against Anaplex in any more than it would if they proceeded separately, and Anaplex will have ample opportunity to respond to any anything that's raised during its proceedings and any evidence that's heard, and I'll be clear about this too, again, for the board, but any evidence that is heard in the Aerocraft proceeding cannot be used in the Aniplex proceeding unless Aniplex was there, which they won't be. So that will be very clear.
Okay, so the plan then is to proceed with Aircraft this afternoon, and hope to hear some good news on the Aniplex matter and make a decision.
Right. If you can also have, if you can have Aniplex show up, at least the attorney, and so that we can resolve the remaining issues with their proposed stipulated order for abatement, that would help expedite matters.
I heard most of your sentence except the first few words. What was?
Oh, I see. Yeah, we're asking that you also request Aniplex to be present to at least work on the proposed stipulated order for abatement that they have presented, because we do have some issues with it. But I think hopefully we can hammer that out, and let's cross our fingers. But maybe by toward the end of the day, we can actually have a stipulated order for abatement with Aniplex.
How can Aniplex work on the order if they're attending the hearing? I didn't understand.
My understanding is it Thunderberg who's the one who's working on the order?
I see. Okay.
Oh, I see. They have another attorney, Mr. No? Okay. All right. So if is that Mr. Castell can't attend today, and so it's Mr. Thunderberg?
Yeah, Mr. Funderburg intended to be there this afternoon.
Okay. So he'll be there, and I guess we can just work on it afterwards or something like that.
Yeah, I'll leave the logistics to you gentlemen.
Okay.
Okay, so someone will be present from Aniplex to work with the district on a stipulation this afternoon?
Yes, Mr. Chair.
Okay, and we're going ahead with the Aircraft and kicking the can forward on the motion to continue?
That's correct, I believe.
Okay, all right, that's what will be done.
Thank you.
Anything further
Thank
before
you.
we close? I hear nothing further. Thank you very much, and okay, we'll see you at 1 o'clock.
Very good. Thank you.
Thank you again.
Bye.
Thank you.
Bye-bye.
We are back on the record. Ms. Prusak.
I just wanted to, Ms. Byrd left off saying that she heard that there were the two provisions or the two parts that were really areas that we wanted to work on. And I wanted to just throw a third area on the table that was very important to me, but not as substantive of a change. Not as substantive of a change as the delay, but an important change to me to discuss, and I'll explain why. In two areas of the intermediate cover, and in particular, I would start with condition 12. Well, it was on page 15. I just have to flip back and forth, but let me see if I can find it. Wait. Okay, it was condition 12. It's not anymore. Wait a minute.
I believe it's condition 10 now.
10, that's the
Page
intermediate.
15.
That respondent shall expand the application? Okay, thank you. Okay, thank you. Okay, so I think I expressed in questions during the proceedings that I have an issue with I think this is the most important provision with regard to the intermediate cover in the stipulated order for abatement, because we know that the LEA intermediate cover enhancement program is proceeding, and I have to agree that it's important that those results show themselves before a particular cover enhancement is chosen. And the schedule that was given by Mr. Singh was possibly 2 months. But I am concerned at the vagueness with this condition, now condition 10, that respondents shall expand the application to additional designated areas. And it doesn't say how far they should expand, and it doesn't say how many. Now, I understand a lot of that is contingent. However, I do hearken back to, I won't say specifically what, but to another order of ours where we were not specific enough with what exactly we were requiring, and as a result, we lost a very important part of a stipulated order for abatement. I do not want that to happen. So, for example, this, as it stands, this provision, this condition could be satisfied by an expansion to one additional, not that it will happen, but to one additional area, and that's it. And now it's satisfied. So what I would like to have put in here is something like, and we can discuss language and see what the parties may or may not agree to, but something along the lines of that the parties shall return for a modification hearing to set an expeditious schedule to enhance the entire surface area of the intermediate cover area of the landfill. So something that makes it clear that there's an intention here, and the intention is that expert after expert got up and said the number one thing that could be done to really affect landfill gas and the effects on this community is to enhance that intermediate cover as quickly as possible. And so I want to make sure that that is the intention of this condition, not to set the schedule, not to require a certain area, not to require any kind of cover, but that be put in there. And I think that that's very important that it be put in there. And then I was also hoping that we might have the parties agree to additional areas. I'm trying to find it now. What was condition number 10? I guess it's 9. Yes. No, 8. I'm sorry. Now 8 on page 14. Again, we heard Mr. Singh say, this is something that can be done right away. It needs anything. Additional enhancement on intermediate cover areas of additional soil. And I'd like to see more than 10 areas, and the reason why is because we heard that 7 are currently in the LEA enhancement program, but we saw a grid with circles around them, both in the county and the city, and we counted at least 35 different areas that are high emitting areas that are of concern. So I'm not sure why only covering 10 is in here as opposed to, say, covering 20 of those areas to get better coverage while that LEA enhancement project is being finalized.
I'm just looking through my notes because there was some mention about the evaluation taking place and not wanting to have in place something that had to be then removed again. And so if while everybody's discussing things, I'll see if I can find that.
Ms. Byrd, present.
I don't recall how I would definitely like for Ms. Byrd to see if she had notes on that, but my recollection was that, I mean, if 10 can be done and taken off, I didn't hear any explanation as to why 20 can't. And it's soil, it's not poly shell or something that might be more difficult to remove. And so, again, it is meant as an intermediate step that will hopefully, I mean, I'm concerned about what kind of soil, because we did hear testimony from, or not testimony, but we heard Mr. Bruin represent, I think maybe it was even on Tuesday, that the soil that they would use for the intermediate cover is the soil that's there, and that they feel that it is good soil. But we also did hear testimony that, in fact, it's silty, gritty, and permeable. So I'm not sure if we wanted to talk about the soil, but for the intermediate step, I think I'm satisfied if they use what is available.
Let's go off the record for a moment. Ms. Present.
Back on the record, I suggest perhaps if we want to at some point, we can just simply ask the parties if they're willing to stipulate to that. And if not, then we can look for that which will support or not support any other decisions we make.
Let's do that. Do you wish to offer the question?
If the board, it seems the board might be interested in, well, I don't know if you want me to ask about both, but let me start with the change to condition number 8 on page 14 to, upon issuance of the order, applying additional soil cover on a minimum of at least 10 intermediate cover areas, if the parties would be willing to change the stipulation to be 20 or some other number.
Mr. Bruin?
Mr. Chairman, I'd much prefer to have all of the proposed modifications to the order in one package so I can talk to my client about it at one time and give you an overall reaction rather than do it piecemeal.
Just two. Mr. Sanchez?
Regarding how you prefer to proceed in response to Mr. Bruin's comment, the district would just remind this board that we had ample testimony from Eugene Sang. He is the individual on behalf of the LEA that will be doing the analysis to direct this, and he supported the condition as drafted.
Well, I appreciate that. Mr. Sang also supported the entire order as drafted and mentioned a balance approach or a holistic approach. But some of the things that Mr. Sang was relying upon in his holistic approach included, for example, I forget the name of it, but the orchard fans or what have you, to change the wind direction, things like that, including things that have not yet been agreed upon as part of this order, but rather will have to be determined as part of the order conditions as proposals and then considered and then adopted. So I appreciate that Mr. Sang agreed with the order as it is drafted. However, that's not to say that it cannot be enhanced for the intermediate.
I would just add, Ms. Prusak, it says at least 10, so it's not limited to 10. I think as Ms. Byrd brought up and was consistent with the testimony that I heard, there were the specific areas that had been targeted for the ICE project, and the whole point of the ICE project was to put on cover, measure it, determine the success of that, and then once that material is determined to be, assuming that that material is determined to be a successful application to get the emissions under control, then to expand that application. So we identified something in the interim that would also help, and so it was the application of at least 10 areas of just soil existing at the landfill, but also we didn't want to undermine or conflict with the ICE project, so it was an immediate addressing odor issues, as well as a project which is intended to be a long-term and ongoing fix to these type of areas under the landfill. So there was that balance of applying something quickly, as well as implementing a project that had quantification metrics measurement with the district rule 1150.1 to then apply that throughout the landfill. So we didn't want to, although there are, no question, there is a benefit to applying additional soil throughout these areas. There's also a project that has been prepared to be implemented, and so we want that to also go forward simultaneously.
Ms. Prusak, relative to the overall program of emission reductions, do you feel the difference between the 10 and whatever larger number might suggest is at this point something you wish to pursue?
I do, and the reason why is based again on the evidence and testimony that was presented to us. We were presented with two charts with a circled enclosed area with a number of grids, which I counted, both on the city and the county, and I counted at least 35 grids, which were highly problematic grids, where emissions were explained to be not always the highest emitting, but more or less consistently. Within those grids, I understand that only 7 are part of that project. I also understood Mr. Singh to say, very enthusiastically, one thing that could clearly be done would be to apply additional soil cover. No other blessing, what's the word? Nobody has to approve, thank you. Approval is necessary for that enhancement of that intermediate cover. As a result, we had the 10 added in here as condition number 8, and I didn't, and I asked the questions, and I did not get an answer as to why it cannot be more when there are so many problematic grids, and we have to wait for months to see the answer or the results of the enhancement project. The enhancement project will go forward, and it won't be affected because those grids won't be chosen. But there are at least 20 others that can be chosen. And I asked specifically, is it hard to take that soil away? And I did not get an answer that it is hard to take that soil back away. So it seems to me that it's very consistent with all the evidence we've been hearing that you gotta enhance that cover, and that is key. So for short term. So that's why I think it's important.
Persuasive. Ms. Byrd.
I can't find specifically, but my memory was as Mr. Sanchez presented, and I'm seeing here that maybe there must have been some difficulty in putting on and taking off, as well as the feeling of, once again, doing something that might have some other unintended consequence. I see that he mentioned they would do that it would be a minimum, and I do remember him saying that that would be the minimum, but that he would certainly be doing more than that, and that the 10 would be the most problematic that he would do first.
If he was, it's a little inconsistent to say it's a minimum and they intend to do more, but it's problematic to do more. So
No, problematic,
more,
that they would do the 10 most problematic ones first.
Right, but the issue...
Problematic to do more. The issue would be putting it on, taking it off, and what... I guess when we did this initially, we didn't have as much information, and I think my feeling was, from what was presented, was that rather than doing something that could be an issue down the line, and then having to fix that the plan was to put on these 10 and continue to run the intermediate cover project, and then from that point on know better how to continue covering these other areas.
Yes.
Let me phrase the issue, I think, in a way that we all can understand, because we've had testimony on this. We heard testimony consistently that for daily cover throughout California, and I understand it to be the practice in many landfills, that 6 to 9 to 12 to a lot of inches of daily cover are put on and taken off every day. If it's so problematic to put that much cover as intermediate and take it off, I don't understand how other landfills are doing it every single day as daily cover. So I haven't heard, I asked the question, is this difficult to apply just this intermediate soil on 20 grids so that In the meantime, while this enhancement process is going on, most of the most problematic grids are covered. I did not get an answer, and I don't think that the evidence supports that that is difficult.
Okay, let me follow my notes here. That was my last day, and those I didn't have filed, so it took me a minute to find them. This might take me a minute, if you're waiting for
Off the
me.
record. Board's going to take its lunch recess. 12:30, board members? That's sufficient. We have a 1 o'clock aircraft.
May I ask, what, the parties have heard a lot of discussion on several provisions or conditions of the order that it seems we are concerned with, and perhaps the parties might use some time during the break to either discuss it amongst themselves or with each other, if possible.
Mr. Bruin?
May I inquire from the board if there are other issues or concerns, or if what we've heard is the sum and substance of the issues you'd like us to address?
I have no other issues. Ms. Brusek?
I had smaller issues, so I wanted to just take a moment while everyone else answers, just to go through and see what they would be.
All I would have would be some dotting of i's and crossing of t's that are just nothing. Okay, anybody else? Nope.
Regarding what subject, Mr. Chairman?
Pardon?
Anyone else about what?
Mr. Bruin asked if there were any other issues besides the ones we have just discussed that he might discuss with the district in the event they might come to an agreement.
I have one,
And that is,
and it's the hours of morning.
yeah, I think that's one of our main issues that they're going to
Okay.
discuss.
I would have that. And I would want to add, however, when Mr. Sands, Dr. Sands, or whatever, came in to support the initial proposal, including in the abatement order, he was allowed to speak openly and very supportive of the concept and the limitations that were being imposed. When he came back, and he began to address the same issues in the same manner, Mr. Sanchez would interrupt him, I noticed, and then he would modify his statements when Ms. Prusek was beginning to pressure him before, I'm telling you, my eyes won't deceive me. And then, of course, you would advise him, he would consult with you before you give the answer. So I don't know what that's all about, but I can tell you that he spoke very freely when he first supported the concept. And he convinced me at that point in time. He said nothing after that changed my mind, because I can see the body language and how they were acting.
Yeah. Any other issues? Ms. Prusek?
There are very small other tweaks I had, but the other issue that I had raised was for the board to consider not a restriction in tonnage, rolling it back, because I do believe that if the delay occurs, it is a more surgical approach, and it does get to the heart of what needs to be done while not delaying filling in the side slopes or what have you. However, I do believe from some of the testimony that I heard at the end of the hearings that I think it's important, while we are assessing during the time between if an order is put in place and a return to this board, and we're assessing how well these measures are starting to work, that there is not an increase in tonnage. And I think that there should be a cap placed at the current level, not to be increased during the pendency. And it could be temporary to be assessed, but that would be one other additional thing that I'd very much like to see.
What would that cap be?
I think, well, we would discuss it, but I think it would be, they cannot increase their tonnage during the pendency of the order until there is a return and a discussion as to whether to increase it. So
Increase it from what?
From current levels.
Ms. Prusik, I can address that now, because I have discussed that with my client. We cannot agree to a tonnage cap. First of all, it's very difficult to apply, and it really becomes a point where a truck arrives at the gate and you have to turn it away, which is a real problem in our business, and I think you've heard that in other cases. And second of all, our tonnage varies from day to day quite a bit. It's hard to predict what it's going to be in the future, but I would also say that we feel that the evidence does not show that there's a fresh trash odor problem at 3 or 4 in the afternoon, which is when the tonnage cap would go into effect. So that's one item that I have already discussed with my client. I thought I should let you know now.
The tonnage cap, Ms. Prusek, would that be a daily tonnage cap or an average over a period of a month?
It could be averaged if necessary. It could be averaged. I guess the point is, we heard a lot of testimony which inherently was in discord with what I would otherwise think about receiving more trash. That's important to reduce the odors. But it just, that reminds me of, you hear about failing businesses that throw good money after bad, hoping that they're going to somehow get out of the fix by pouring in good money after bad. And I see it as pouring in supposedly good trash after bad. And I don't agree with that, and I feel that there needs to be some way to just stem the tide until things are fixed. And if we don't, the problems will simply mount. We know that the side slope issue is not going to be filled in overnight by additional trash. There's plenty of trash coming in to fill those side slopes over time, and I don't think that should be an issue at all. And so I think it would make sense if it were a rolling average, any way that makes sense within the business model, but that helps to assure that we're not going to see a big rise in tonnage until the problems are fixed. That's what I'm really looking for, and I don't have it worked out, and I think we're hearing from Mr. Bruin, but maybe he would change his mind if it were part of some kind of rolling average or something like that, and I just, at this point, want to throw the concept out.
I seem to recall some testimony regarding the working phase not changing appreciably as a result of the amount that's coming in. And it's off that working phase that the odors come out.
My suggestion is not to address anything in particular. It's not that I feel that less trash is going to affect the fresh trash odors immediately, because I understand, and I did hear that testimony about the working face size and that there are restrictions and all of that. It is merely to understand that there are serious, I think we all can agree, based on the testimony, there are serious problems at this landfill. And to allow, while we have what would hopefully be an extremely strong order to start fixing those problems, to allow the landfill the ability to increase, I don't know if it will, from 9,000 tons per day to 12,000 tons per day, I think will just simply exacerbate the problem and make it more difficult for these things to take effect. I think these things need to be fixed and take effect before more trash is brought in. And I'm not making the argument for less. I do like the surgical approach of less occurring naturally, the right kind of less occurring naturally by the delay in the morning, and especially of that organics from the city of LA. But I think a cap is smart because, again, how do you fix a problem if you continue to add to it?
And the cap you're proposing is not daily, but a monthly cap to take care of the concerns of the differences day to day.
If that would work, a monthly on average, I think would be fine. So there's flexibility at the facility, yet we are accomplishing just maintaining a status quo while all of these issues are sorted out.
Okay, I think we understand. Any other items for the parties to discuss? Okay.
Mr. Chairman, may I inquire as to the afternoon schedule? Are we trailing and starting right after lunch, or?
I think we have to. I'm planning to come back at 12:35 and hopefully finish this. Somewhere along the line, we're going to have to make a decision as to whether or not, if it appears we're not going to make a decision promptly, we have to continue it to another day because we have another very important process going.
Well, with that end in mind, that we'd all like to finish today, we will report back to you at 12:35?
Yes.
Okay, thank you.
Not 12:36. We're in recess. We are back on the record. Okay, Ms. Byrd, you were looking at the transcripts?
Yes, on our lunch break, I took a look at the transcript, and I don't know if we're allowed to listen to the transcript from the transcriptionist who's here, but it can be played, I think, or it can be recited. But what I did find, and it was at 11:29:30, there was some discussion from Ms. Prusak with the witness, and I don't know if you want to just take what I heard, but I can tell you how I processed what I heard, and that effectively there would be 17 out of the 30, and let's see.
And these 17 would be the 17 most impacted.
Of the worst.
Of the worst.
Yes. And let's see. There was some discussion about removing the soil, and it was mentioned, and not that it was specifically said how difficult it would be, but that after putting soil on, that they would be removing about 20 inches of soil. And there was a statement that no matter how much soil, even if you put 2 feet or more of soil, gas is still going to be able to move through the soil. So,
say that again.
Even if you put 2 feet or more of soil, gas is still going to be able to move through the soil if the vacuum isn't improved. And basically saying the pluses and minuses were being that he was evaluating the pluses and minuses of doing those two. So there is nothing that specifically says it's impossible. At least I didn't find that. Nothing that said it was impossible to do. But I did want to at least mention that there are 17 cells involved and not just the 10.
Ms. Brusek.
No, thank you for going back over that, but that is consistent with what I thought. The 7 cells are the ones that the LEA is currently looking at. There were 35 total that I counted that were just within those boundaries in both the city and the county map that were the most problematic. There were many others in addition to that had found high emissions, but those were the highest emitting grids. So 35 together, but only 17 that would be covered. And again, yes, he did say 20 inches of soil would have to be removed if soil isn't the ultimate cover, but a lot of that is already there. As intermediate cover soil, you're just putting more on. And as far as how difficult it is, I would go back to the idea that this is used as daily cover, and it's put on and removed quite regularly without difficulty. At this landfill, it was put down, it wasn't peeled back, but it's peeled back regularly as a regular practice at other landfills, so I can't imagine it is that difficult. And I do recall, thank you for the testimony regarding that it's never going to be perfectly not permeable, but there was also, by Mr. Sang, testimony that by increasing the cover, enhancing the cover, whether it's with more soil or whichever is determined to be the best, but any way you do it, it does in fact increase the vacuum within that cell. So, no, I think it'll still be permeable, especially if the soil is used that has already been used, because we've heard testimony that it is silty and it is permeable. But the more you can put on, according to Mr. Sang, it can be done right away, and the more that can be done, the more you might increase the vacuum. And so why not do it for more cells? I think it's important, especially when 35 have been indicated as highly problematic.
Actually, Ms. Prusak, I believe that these are not daily cover already. They're intermediate cover already.
No, of course, yes, they are intermediate cover, but I'm saying, as far as how difficult it is to take that soil away, I guess my only point was the analogy to the fact that this same soil is used as daily cover at many landfills, and daily 9 to 12 inches are put down and peeled back every day. So if that were difficult, that wouldn't be a regular practice. I guess that's my only
And I understand what you're saying. I'm not disagreeing with that. I guess my understanding of the operation of a landfill is, well, while they are peeling back daily cover is not the equivalent of 30 grids. It would just be what was placed there the day before. You know what I'm saying? It would be the working face is covered at the end of the day,
Yes,
not the entire grid.
that is correct.
No, I
That is
just wanted
true.
to
That
make
is
sure
true.
that we were saying the same thing.
You're right, that it is somewhat more difficult, but I don't think I think it just indicates it's not that difficult, if they could do it every day for the working phase. Even if it is more area, I agree, it is more area.
Okay, it's a lot more area, that's all I'm saying. Like, okay.
Mr. Sanchez or Mr. Bruin, what was the result of your lunch discussions?
Yes, thank you, Mr. Chairman. We have considered the hearing board's comments, and there are some requests that we can agree with, and some we have some alternate proposals. So I'll just go down my list. And first of all, with respect to morning hours, it's acceptable to us to have an across-the-board prohibition on transfer van loads coming into the landfill 12 months of the year without regard to weather. So we would eliminate the adverse weather protocol program altogether. With respect to banning route trucks in the morning hours from 6 to 9, and those are, again, transfer vans are about 78% of the waste volume that comes in the morning. We think there are some logistical issues with the ban on route trucks. Remember, these are the local route trucks that collect garbage in Granada Hills. And they're out early in the morning collecting garbage from residents and businesses. And if they can't go to the landfill until 9 a.m., what happens? Well, if they park in the yard, that means there's perhaps a 2-3 hour delay before they can start their next route. So a ban on route trucks means that the route trucks are going to the landfill now will have to be rerouted, which is a pretty major undertaking in the business. It usually takes a month to 3 months to figure that out. Routing is a very complicated issue, and basically it means some people's collection days will change. Morning collection might turn into an afternoon collection. That's the kind of thing that gets the phones at City Hall ringing. So my suggestion is that, and the other thing I should point out is that the traffic study that was going to be a precondition to all of this has been removed from the abatement order. And so there is not going to be a study. What we're suggesting is that the prohibition on transfer vans would start immediately upon approval of the stipulated abatement order. But if you're going to look at route trucks, we suggest that you study that first so you know what you're getting into and what the consequences are of requiring haulers to reroute their vehicles. And the other advantages, because it's going to take some time to consider anyway, you could have a status report and see how this new program is working. Keep in mind, we're also moving the working face. Probably first part of March or so, we're going to be another half mile away. So we think we can manage odors from route trucks. And so we would respectfully suggest that the board consider confining this order at the moment to all transfer vans, 6 to 9, 12 months of the year, regardless of weather. And that's our alternate suggestion with respect to morning trash odors. With respect to the intermediate cover program, we're fine with the proposed revision to Section 10 on a return with a schedule. That makes sense. With respect to the request in Condition 8 that we cover 20 grids with soil instead of 10, that's acceptable. We've checked it out. We'll believe there'll still be enough problematic grids for the ICE program to study. And then finally, with respect to a proposed tonnage cap, we're not in favor of a cap for a variety of reasons. As I said before, it's very difficult to administer. It causes a lot of problems at the end of the day when we really haven't been getting fresh trash odor issues. I believe that Ms. Pressick's concern was based on a comment that Mr. Hunter made during public comment that Republic had been awarded a franchise agreement with the city and that he said it was going to result in more trash going to the landfill. what the city of Los Angeles has done is they used to have an open permit system for commercial haulers. So that, in other words, haulers that serve businesses or commercial establishments. The city collects its own residential waste, but they've allowed private haulers to collect commercial waste, and it was basically an open market system so that Republic or Waste Management would go to Joe's Market and say, we'll pick up your trash for X amount of money, and then they would say, yes, we'll go with you, and you sign a contract with that customer. So we had a certain percentage of the total market under the old system. What the new system is in the city is they're going to exclusive franchises for commercial pickup, so that they've divided the city into 8 large zones and 3 smaller zones, which are geographic areas, and they've said, Republic, you pick up all the commercial waste in this zone. Waste Management, you pick up all the commercial trash in this zone. And based on our projections, we don't think there will be a significant change in the total tonnage going to the landfill, because we do have exclusive franchises now in 2 large areas, but other people have the other 6 large areas and the 3 small areas. So we think, looking at those areas that we've been awarded, it's going to be a wash. But we don't know that for sure, and we just signed a contract agreeing to take the waste from the city. We do not have any other major contracts coming down the pike. If you look at our tonnage over the last 5 years, it's been pretty flat. I think we gave Dr. Lerner a chart showing what our tonnage had been. So what we'd like to make is an alternative proposal on this, which is, as part of our status reports to the board, we report to you on our tonnage. If there's a spike or something happens like that and the board has a concern, we can have a discussion at that time. But we're pretty confident our tonnage is going to be flat. There are 2 things that always affect tonnage. One is holidays. We're coming up on Christmas. As you probably know from your own experience around the holidays, there's a lot more trash out, causes a spike. There are some soil jobs. We hope to be bringing in clean soil to the site to augment the on-site soil. And obviously, when that happens, we bring in more trucks, but it's not trash, it's not garbage. So for those reasons, we would suggest not a tonnage cap be placed on the site, whether it's monthly or some kind of rolling average, but rather that we report to the board on our tonnage, and if there's a spike in tonnage, then we can have a discussion with the board at that time. And I believe that covers all of the open issues that were raised before the break.
I have a couple of questions for you. With respect to the morning hours, I heard you say all transfer vans,
Yes,
regardless of whose they are.
correct. So it'd be the city, third parties, and Republic, all would be prohibited from unloading prior to 9 a.m., regardless of weather.
9 a.m., not some 8 and some 9.
No, correct. 9 a.m. across the board.
And with the tonnage cap, since you expect no change, what is wrong with an average cap that reflects what you've been doing? A monthly average.
The difficulty with the monthly average is it's either so high it makes no difference, or it's low enough that it means we have to start turning away trucks at the end of the day, which really plays havoc with operating the site. We believe overall there isn't going to be a significant increase, but again, we haven't started operation under this new franchise agreement we've signed with the city. We don't know for sure how that's going to affect our tonnage. Again, we don't expect it's going to be a significant change either way. It could even be a decrease, we just don't know.
Ms. Persak, you have any questions for Ms. Bruin before we go to Mr. Sanchez?
I did. The local route trucks, so if they're able to come in, then the working face gets open. What's the effect of the fact that we've heard that the working face is the size of the working face? Is it that the local trucks are going to bring just to certain, I mean, we did see some pictures where there's the alternate daily cover, and then there's this part here, which is a small part of the working face where the trash was placed, and the entire thing is not disturbed. Is that the way it works with because my question is, now that we think about this, will there be any effect of a delay if you're still bringing in local trucks if the entire working face is open?
Well, I don't think the prohibition on transfer vans is going to have a significant effect on the overall size of the working face. But I do think it has effects on the potential for trash odors to be generated because, keep in mind, waste from a transfer station has sat there for a while. The collection trucks go to a transfer station, it gets dumped on the floor, then it gets moved into a transfer van, and then it's got to take the trip from the transfer station to the landfill, and all that waste gets aerated. It starts decomposing in the truck. It's already been decomposing. So transfer van loads tend to be smellier, so when they get deposited in a working face, you're going to get odors from that process. Route trucks, if you can use the expression, it's fresher trash. It's right off of the route. It's much less tonnage, about 22% of the total tonnage, so we'd be restricting 78% according to Mr. Sung's analysis. But there still will be a working face, and as I said before, the other consideration is that in the first quarter of next year, the working face is going to move about a half mile farther from the neighborhood. So if we just take in route trucks during those hours and we're moving the working face, and we have all the other measures that are covered in the abatement order, such as dust bosses, misting lines, the use of ADC, we think that will take care of the issue of morning trash odors.
Okay, but I'm still trying to understand. The working face will be the same size, so now it's delayed, the opening is delayed till 9, but because the local trucks are coming in, the working face is open for business.
It will be open for business at 6 a.m. for route trucks only, yes.
But its entirety will be disturbed and open all the same as if the transfer trucks, the only difference is the amount of trash that's deposited across it and whether it's been aerated overnight or not, and the strength of the stench.
Right, we're basically cutting down on the total of trash going onto the working face at any one point in time because we're taking the transfer vans out of the mix. So I think you saw the picture of fresh trash being placed on the working face with the strips of ADC. The pile of fresh trash is obviously going to be smaller if you have less waste coming in at that point in time in the morning.
Okay, so as part of this comeback here that you're doing right now, are you agreeing to, if we wanted to put in a condition to do that study of routing those trucks?
If the board wants that, we can provide you with the study.
Okay,
Yes,
and then a comeback, and then so we could consider whether or not that should be part of the delay,
that'd be fine.
or could be. I don't know if I have another question. Thank you.
So you mentioned comeback report on a spike. What would your definition of a spike be? How much more would it have to be considered a spike?
I wasn't thinking of anything specific, but I would think a 5 or 10% increase would be significant on an average.
I think that would be up to us to decide.
Okay.
Precisely,
When he
yes.
said spike, I just didn't know what that meant. And I understood you to say that 78% of all of the trash then will be moved to not coming to the landfill prior to 9 a.m. Because of the...
Right, the transfer van loads make up about 70%, 78%, according to Mr. Sung, of the volume going in the morning hours to the landfill from 6 to 9. So that would either go somewhere else, diverted to other sites, or it would be deferred until later in the day.
Okay, thank you.
Mr.
Can you refresh my memory? One quick comment. I remember I asked you, asked for a graph about the relationship of complaint to tonnage. The tonnage remained relatively flat, but there was this progressive worsening or progressive increase in complaints. So just graphically, I don't think much is going to happen unless deliberately you decide to increase it. And I think that's what maybe the real hidden message of this concern about capping. That's one comment. The other comment is, the local trucks that will be able to come in between 6 and 9, their percentage of organics is going to be much greater, isn't it?
Well, those will be residential trucks?
Yes.
There may be some commercial trucks too, actually, and come to think of it, I spoke too soon. I think it would be a mix of commercial and residential.
So what percentage of those loads in the morning is going to be fresh, that's going to be allowed to come in between 6 and 9? Because if the fresh organic material is one of multiple sources of odor, then we may not be gaining anything from this. I don't know where that's. How do you manage that? How do you prevent that odor from being there between 6 and 9? If these residential and some commercial trucks are being allowed to come in that early in the morning?
Well, you're going to have a smaller pile of trash that's fresher, not quite as smelly as trash would be in a transfer load. We have additional dust bosses, which are misting cannons that put odor neutralizer in the air. And we have other things that we do at the working face to control odors. The other thing that I mentioned was going to happen is in the first quarter of next year, the working face itself is going to move away from the neighborhood by about a half a mile. So I think your question is, what makes us think that allowing route trucks in is not going to pose a problem? It's a combination of all of those factors that I just mentioned. And again, you can't reroute the route trucks overnight anyway. So it makes sense in our view to do a study and to look at it and to have a report back to the board. And then you can look at what the morning odor complaints have been in the interim and decide if the program's working or not.
Okay, let me just respond to you. So let us say, just for the argument's sake, that there will be no discordance among the board members about what you plan to do between 6 and 9. What I'd like to know is, with that fresh trash, you do have ways of trying to control the odor emanating from that at the site, the active site. Is there sufficient amount of equipment there to really try to offset those odors as much as possible? I mean, this is not quantitative, it's a qualitative question that I can't give you the quantitative stuff. But that, I think, is a critical variable, because a lot of the complaints are between 6 and 9. We need to be sure that if this stuff is going to continue to roll in, we may not be doing anything. You know, at the end of the day, those complaints are going to be there. Then we're going to scratch our head and say, what did we do wrong? What did we let happen? So I need to know what as specific as you can be right now. Tell us what you can do to prevent that trash odor from emanating between 6 and 9. Because it's coming in there and it's sitting there waiting to be compacted, et cetera, et cetera.
Well, again, there are a lot of things we can do. As I said before, it's going to be a smaller pile, and it's going to be fresher trash, not quite as odorous as trash in a transfer van. We run compactors over that trash immediately to crush it and condense it. We're looking at some new technology to actually apply an odor neutralizer spray to the working face to see if that's feasible. We have plenty of equipment, and we're devoting a lot of resources to doing everything we can to control morning trash odors.
It's so difficult. I really want this thing to work. And I want to give the people out there who've been waiting years for some relief to be sure that whatever we're doing, we're making those trash odors vulnerable to the community, that we're doing everything to abate those odors by doing everything that you can. And I don't know enough about the system to tell you, you need to do A, B, C, D. You have to use this bomb, this spray, this can, whatever. That's my problem.
Ms. Prusak?
I think this board is awakening to a disturbing fact, which is that the delay is not a true delay, and that there are issues here. So this board member would like to see those route trucks also delayed. So my question to you, Mr. Bruin, is rather than a study, which is the question I asked you, can we have a proposal of how to reroute those trucks on a return? And if so, how long might that take for that to be studied, evaluated, and a proposal made?
Well, what I was told by Mr. Sherman, who's the general manager of the landfill, used to be in the collection business, is it takes 60 to 90 days to reroute a large area, and we're talking about rerouting a large area. And since this involves the City of Los Angeles Bureau of Sanitation, we'd need their input. So if the question is how long would it take to prepare a study, I don't know for sure. I would guess 30, 45 days to talk to the city and find out, what they would do and where they would bring their route trucks and what impacts that would have on, traffic or other issues.
I don't know what's involved in rerouting. 60 days sounds like a lot. Okay, Mr. Sanchez or Ms. Manwaring?
I thought I saw Dr. Lerner raise his hand. All right. Thank you so much for allowing us the opportunity to address these issues. We were able to confer with Eugene Tsang over the lunch break and appreciate the opportunity to do that. Regarding potential changes to conditions 8 and 10, the timeline with a more specific schedule sounds very reasonable to Mr. Tsang, and increasing the number from 10 to 20 is not objectionable. As to the cap and tonnage, for reasons very similar that Mr. Bruin described, the district could not at this time support the tonnage cap as proposed, mostly due to some operational concerns and how that would apply. So the district is not able to stipulate to that at this point. Now let's talk about the hours delay. I'm a little bit concerned about how this has been communicated. This is a substantial compromise. The district came at you with a delay of 6 to 9, Monday through Friday, for all vehicles. What we have before you is a delay from 6 to 9, Monday through Saturday, for 80% of the trash that's coming into the facility. We got everything we proposed with the exception of that 20%, and there are good reasons to consider whether or not that 20% is necessary in order for this particular proposal to have an impact. I'd also like to remind this board, referencing District Exhibit 37, which was a summary of the timeline that you can anticipate things being installed or impacts being felt. There are new monsoon misters at the working face. There are additional improvements and changes to best practices taking place at the working face. So yes, this 20% of the remaining trash that's done by the local haulers that may or may not have impacts that we may or may not be able to understand on an expedited time basis. There are other changes to address this. Treatment of trash at the transfer station, treatment at the working face. This is a holistic approach. The district got 80% of what it originally proposed. Please don't overlook that fact. That's all for this time.
I want you to go over that just so I understand clearly what you said.
Specifically with the hours, or as to all three items that are on the table right now?
No, on the hours.
On the hours, okay. The district originally came at you with a hatchet. One element of that hatchet was delay everything coming into the landfill Monday through Friday from 6 to 9. The proposal before you now is Monday through Saturday, 6 to 9, as to 80% of the trash coming in. And you have evidence to suggest that that may be the stinkier trash. We're 80% of where we were. In addition, we do have these other measures that are intended to treat fresh trash odors at the transfer station, at the working face, in addition to the eventual removal of organics, which will also have an impact. Does that help clarify? The district would also, if the board is willing to entertain at this point, we also did our homework on the break and pulled up some of the transcripts to look at, to try to review some of the testimony. And Mr. Sanchez has prepared that, which we could distribute. We have found excerpts from the October 25th, 2016 hearing, specifically Mr. Singh's testimony as to hours and tonnage, and also as to this will affect 80% of the trash coming in if we delay transfer trailers, but not the local route trucks. Can we distribute that?
Sure.
You could, yeah. I do agree. I recall that testimony. I have those percentages.
Just while this is being, either of you can answer this. Of the 20% that's coming in the morning, that's coming from local sources, approximately what percentage of that is organic or potentially smelly trash?
I believe it's the same percentage as the general waste stream. It's around 20% of that.
So we're talking about 40% of the total. I mean, 20
20% of 20%.
Yeah, 4% of 100%. Okay. Whoops, thank you.
May I propose that we go off the record to allow you to review this
Yes,
portion?
we're
of
off the
it?
record.
Mr. Brewer, did you get a copy?
Yeah, I've got it, thanks.
Excerpts. The very last page is not in numerical order.
Here, Mr. Singh is asked to review a document. Which exhibit is that?
That is Exhibit DD from
D?
respondents, double D.
Okay. Thank you. We're off the record. Go ahead. back on the record. You wish to discuss this further?
Just a couple quick points to bear in mind. With regards to the conversation about how one can implement daily cover, so can that ease of implementation be transferable to intermediate cover? One factor I'd like to remind this board of is daily cover does not have piping and wells. So that is a huge factor and a difference about scraping back and reapplying soil as to those two different areas of the landfill. I realize that there was so much testimony about so many things, and what we were able to collect for you during that brief lunch break may not speak to all the remaining, I'm sure it doesn't speak to all the remaining issues. But I do want to point out that I had direct examination of Mr. Sang, and so if there are any concerns or allegations about how the district presented that evidence or testimony, those should be directed at me, not Mr. Sanchez. But that said, I think he was a very credible witness, and if you review the testimony of Mr. Sang, you will see whether or not he supported the original conditions, and you will see where he ended up in the most recent hearings. Thank you.
Okay. We have another hearing we need to get to. I sense we're not as close to a decision as I'd like us to be.
Mr. Chairman, may I just make just a quick comment? I think we've essentially agreed to all of the requests from the board, except on the question of route trucks, and there we've agreed to do a proposal, as Ms. Prusick suggested. And on the tonnage cap, we've said we would report to you on tonnage so that if there was a change in that, you could have a discussion with us at a further status conference. So to me, I think we're in accord with the Air District and the hearing board, at least as to the items that we've been discussing thus far.
We've heard that there is, I think, substantial movement on the part of the parties to satisfy the board's concerns. I'd like to hear a motion. Ms. Prusak?
I'm not sure to make a motion, but I think just because we haven't gone through line by line, or I know that there were, you said cross Ts, dot Is, there were some things I might have wanted to put in, but I guess I just wanted to make some short comments. First of all, I just wanted, because this hearing is so well attended and because it's being webcast and because I know a lot of people are watching and they're listening, I just wanted to make a quick comment because I'm not sure it's been communicated by the board who is considering this stipulated order. But I can speak for myself, and I'm sure I can speak for most of the members of the board, that I think that the district has done an excellent job in terms of what it represented to us. It was trying to do throughout this hearing was to hear the evidence, hear the experts, and try to come up with the most effective order because, frankly, we heard the experts saying that the cap or the reduction in tonnage was just not going to be effective in that way. And so I think what was given to us was a real effort to do that, and I just wanted to say that out loud and on the record. And I also wanted to say that I truly appreciate the effectiveness over a very short lunch of coming back on the part of both parties. And I know that this board has had a lot of experience or some experience on another case that is similar in nature with Mr. Bruin. And I don't know that there's ever been issues that have been asked or raised by this board that Mr. Bruin has not attempted to address very effectively. So we can talk about these, but I feel that this is a very strong step in the direction that I was looking for. We could talk about them each specifically if we want to. And with the returns, that I hope that we would make sooner rather than later, at least with respect to evaluating this delay and the route trucks, and to be able to see whatever proposal might be put forth, should it be necessary. We can talk about that and timing, but I think that I'm a lot more comfortable that this will make more of a change, or more of a difference.
Any other comments on the substantive portions of the proposal? Ms. Byrd?
If what you're looking for is whether or not there's consensus, I think that I was pretty comfortable with the district's order from the beginning, and I was willing to accommodate other items that board members might have, and I guess I had confidence that we would be bringing parties back and that we would get some things done, but maybe I was being optimistic, I don't know, but I was. So at this point, I am comfortable with what we have with the proposed elements that have just been mentioned, and I'm willing to make sure that the other board members are comfortable as well. I think we addressed the items that we started out saying that needed to be addressed, and for that, I think that we can move forward. I don't know that I feel that I need to go line by line, but if there are some specific things that a board member might have to bring to light, I'd be willing to do that.
Yeah, I wasn't proposing line by line. I was proposing going through, and each of us, if you have some minor items, change a word here or there that's not, doesn't make any substantive change. That's what I was proposing. Anything further? Okay. If then we have some level of consensus, I'm going to go through the pages and ask each of you, ask all of you to indicate if there's any small change that you'd like to see. First of all, on page, Senator?
Mr. Chairman, at one point in time during this discussion, we were talking about traffic studies. And I guess as we go through line by line, might I suggest, however, if the city is requested to do a traffic study, I think you mentioned that, then of course that could be expedited. I think you mentioned 45 days may be an ideal time limit to come up with a traffic mitigation plan.
You're talking about the traffic mitigation plan, or the routing of the, rerouting of the route trucks?
If you reroute them, you still need a traffic study.
Mr. Bruin, do you still need the traffic study for the rerouting?
Excuse me, I thought that would be part of our proposal, is we would talk about traffic impacts, as well as any other logistical issues associated with a proposed rerouting.
Okay.
And the part that the city would play could be expedited in terms of traffic studies, traffic pattern. I mean, you mentioned 45 days, but
I don't think I mentioned 45 days. I did say that since I didn't know what it takes to do that.
Right.
It seemed like 60 days seemed rather long.
Yeah, well, 60 is long, yeah. And they can put this on fast track. That's all I'm just saying. If you need it done, it can be fast track, whatever you need to do in order to be compatible, to comply with the guidelines.
Okay, on the first page, we're reminded that the second page, that some dates were left off. Those need to be added in, December 13th and 15th. Any other changes on page 2? On page 3, on line 12, rather than line 12 starts surface of landfill and gas and causes odors. I would like to see and causes odors removed, and instead including odorous gases. So the sentence would read, the district alleges respondents are insufficiently collecting the amount of landfill gas currently generated at Sunshine Canyon landfill, which can contribute to emissions of landfill gas from the surface of the landfill, including including odorous gases. And the reason for that is that up in paragraph 5, there's no mention about odorous gases. In fact, one of the citizens pointed out that all it talks about is methane and carbon dioxide. So someplace we need to acknowledge that there are odorous gases.
Yes, if you go to line 5 in that, on page 3, line 4, it says methane, carbon dioxide, landfill gas unless adequately may escape from the landfill into the atmosphere. Doesn't mention anything about odors. That's what we're here about. And I think it ought to be mentioned here, the disposal of waste and its relationship to odor, not methane gas or carbon dioxide, the odor, the odoriferous molecules that travel with this. So if the language could be slightly added in an analogous way, as you just mentioned in line 12,
Okay.
that would make me very happy. Thank you.
How about this in paragraph 5? Rather than that first sentence, insert the municipal solid waste disposed of in Sunshine Canyon landfill generates landfill gas as it decomposes, period. The major components of the landfill gas are methane and carbon dioxide. The landfill gas also contains odorous gases in lesser concentrations, including hydrogen sulfide, and then I dropped it there because there are other compounds, mercaptans, aldehydes, etc. And someplace in the testimony we heard what those compounds were. Would that satisfy you?
Very much so.
Ms. Brissett?
Does that include the testimony that we heard that it also will carry the actual odors of the trash with it? Like as it goes through the trash and comes up, maybe the gas component itself may not smell, but it will carry along with it the odors of the trash. I don't know technically or scientifically how that's stated.
I think this covers it. It says the major components of landfill gas are methane, carbon dioxide, but it also contains smelly stuff.
If I want you to say that well, no, not that. I want to understand from you that you believe that means that it's carrying the odor, the smelly stuff.
Oh.
And that there's other things too, the VOCs and all of that.
Let's see, the landfill gas also contains, because someplace we say it generates landfill gas, and it contains these compounds that smell.
Is it an exhaustive list? I'm sorry.
No, and that's a problem for me, perhaps. I would stop, rather than identify the individuals, because it can be a long list, it just stop at the landfill gas also contains odorous gases in lesser concentrations, period. Senator.
Right. The gases germinated because of the organic material creates the gas. And of course, when the gas migrates to the surface through this sand area, the odor travels with it. It's like transporting the odor. That's why they put the two together. But you can have an odor in other parts of the landfill where there's no gas at all. But that's,
And you're right, you're saying that there are other odors other than landfill gas odors. the fresh trash. So I don't know that that is covered anywhere else. Do you see it?
Speak specifically to the gas.
It speaks to the landfill gas, which is generated within the landfill. It doesn't speak to the odors, and as Senator points out, doesn't speak to the odors generated from the disposal from the work surface.
I think this paragraph addresses the collection, so maybe that's why it only speaks to the gas, because the subsequent sentence talks about the adequacy of collection. Maybe there's another paragraph that would address that, and this one just addresses the collection of the gas.
Mr. Chairman?
Yes, sir.
Might I suggest adding a sentence to, at the end of paragraph 5, that says that landfill disposal can also cause fresh trash odors?
Yeah.
That would do. Landfill disposal. Senator?
Yes, sir.
Well,
Oh, I thought you wanted to speak.
may I comment? But
No,
the
no.
senator was saying fresh trash, there are other odors that are stinky odors, so to speak, that are not related to the fresh trash. They're continuing odors from other parts of the landfill. And they have nothing to do with methane and CO2. I think that was your point.
Right, I thought
So
it could-
the fresh trash odors is very important, but there is part of the landfill that is odoriferous.
There's three. We were told there's three sources, three kinds of odors. The fresh trash, the odors emanating from the surface of the landfill, and I think the other one was the leachate. How about liquids emanating from the surface of the landfill may also cause odors.
Oh, boy.
Everybody okay with that? Okay. Anything else on that page? Page 4. On page 4, paragraph 16, about the middle of the paragraph, it talks about force majeure and has a list of things that would be force majeure. I didn't see in there labor strike. Seems like that should be one. Mr. Bruin?
I agree.
District agrees, okay. So we'll insert labor strike someplace in line 21. Anything else on page 4? Page 5. On page 5, lines 19 and also line 21, it talks about AB 1826 provided that by April 1, 2016, businesses that generate 8 cubic yards of organic, that's a very specific number. Does it not say 8 cubic yards or more? Or should it be only, okay. If we can add or more, then on line 21, where it says 4 cubic yards or more should be added. Anything else on line page 5? Page 6?
Requires, am I to understand, this activity.
And
That's what the bill requires.
yeah,
Okay, all right.
page 6. Page 7. Ms. Brusek?
I had a question because I thought Mr. Bruin had just represented before that the traffic study is no longer part.
There's two things here. There's the traffic mitigation program and a traffic study. Those were two different concepts.
Okay.
All right.
So do we need a change on page 7?
Mr. Bruin,
Yes, sir.
the study, the mitigation program is provided after the study is conducted. Is that not correct?
Well, I think the intent of this program is to avoid things like vehicle queuing in areas near the landfill where that could become a problem. So we were to, I think this requires us to come up with a program that we can follow to make sure that doesn't happen.
We have to study it first before you impose a mitigation plan at that site. So however you want to write it,
We'll do both.
all right?
Ms. Prusek, now we're coming into your ballpark.
Okay, so what I'm understanding is that the parties are in agreement to year-round have the 6 to 9, well, just the restriction where there's no transfer trucks before 9 a.m. Is that correct? No adverse weather protocol.
Correct.
Okay, so then we would need to take out a lot on page 8. Just trying to read how we could put 2 and A together. We could say, respondent shall, upon issuance of this order, prohibit the unloading, dumping of all transfer trailer loads from all third parties, including the City of Los Angeles Bureau of Sanitation, from occurring any, shall prohibit from occurring any earlier than,
9.
and 9. AM during weekends and Saturdays,
Including?
period. So,
Do you mean to say weekdays and Saturdays?
did I say?
You said weekends.
Sorry, weekdays and Saturdays. So essentially, if that works, so we would be taking 2, respondent shall upon issuance of this order, comma. Then we would take out everything from implement to set forth below, and instead put in the word prohibit. Then we would take out A with the underline during the period from October 1st through March 30th. So then it would pick up again. So respondent shall, upon issuance of this order, prohibit the unloading / dumping of all transfer trailer loads from all third parties, comma, including the City of Los Angeles Bureau of Sanitation.
You omitted Republic. So I think before you say,
Oh.
you would say from Republic transfer stations and from all third parties, comma, including the City of Los Angeles Bureau of Sanitation,
Okay.
comma, from occurring any earlier than 9 a.m. during weekdays and Saturdays.
So sorry, so the unloading and dumping of all transfer trailer loads from Republic and all third parties, including the City of Los Angeles Bureau of Sanitation, from occurring any earlier than 9 a.m. during weekdays and Saturdays, period. And then everything else in A is deleted.
You're deleting October 1st through March 30th, correct?
Yes. And then all of B would be deleted. Okay, and then I guess we could make it A. Going right into respondent shall during modified operating hours. And that would just go right into the independent. Okay, but now, this would be a good place. And by the way, I appreciate the addition of the little I to the independent third-party odor monitoring is not intended to supplant the complaints received from the community, Van Gogh Charter School, or the district's public odor complaint investigation policy and response process, nor is it intended to provide evidence of the absence of any nuisance condition. But this would be a good place, maybe as a new B on page 9, to put in the requirement of a proposal to reroute the route trucks. I don't know how we would say that, but if there's no suggestion, or if there is, I would hear it.
You could say, you could have it read, the respondent shall submit to the executive officer and hearing board, we have that language elsewhere in this order, a report within 45 days of issuance of this order to restrict, to study and potentially restrict route collection truck unloading and dumping during the hours of 6 a.m. to 9 a.m.
No, it's not a, I'm sorry.
You have to adopt a mitigation plan that dictates where the route's going to be, when and where. That's what a mitigation plan is.
I was addressing the language we suggested to
That's the
prepare.
proper place to insert it.
May I ask, okay, in what you just said, I didn't get the whole thing, but respondent shall submit to the executive officer and the hearing board a report within 45 days to,
Why don't we say on the feasibility of prohibiting route collection trucks from unloading and dumping at the landfill during the hours of 6 to 9 a.m.
I mean, I assume it's feasible. Would it be more of how it would be done? And then it could be considered by the board? The plan was more what I was hoping and was looking for. And for the board to consider during a modification hearing based upon what we see as happening to the number of complaints, and is this delay working without the routing trucks? But I guess the whole point is to have in place that plan, should it be required, because
So
it
it
is
would be a
concerning.
proposed plan to prohibit the unloading and dumping of route collection trucks during the hours of 6 to 9 a.m. on weekdays and Saturdays.
Okay, so respondent shall submit to the EO and hearing board a proposed plan to reroute. Can you read the rest of that?
I think we should just say prohibit, because we're not doing the rerouting, it's,
The city does that.
To prohibit, I didn't either.
it would be a proposed plan to prohibit the unloading and dumping of route collection trucks at the landfill during the hours of 6 to 9 a.m. Weekdays and Saturdays. So it's parroting the same language as in the transfer van section.
That plan rerouting, consent to reroute must come from the city.
Of course.
So
We're not going to tell the city how to reroute its collection vehicles. We're simply going to report on, provide a plan and consider the consequences of the plan. So you've got a sense of what are the consequences of doing this, and
I was just trying to explain how you get it done. So when you put it in writing, it'll be done. Otherwise, then it's not being done. So I would say that as the former chairman of the Transportation Committee is trying to suggest the appropriate way to get it done, you let the city, you come up with your idea of a route that may be required to meet the terms and conditions of this abatement order, and have the city reflect on it. How do we get it done in order to do it within their guidelines? And then they would do a study, and they would come up with a mitigation plan that you guys work together to make it happen.
We'll do that.
Thank you.
May I, since we're still in deliberation, I just wanted to say that I wanted to see the delay 6 to 9, and but I am happy with, for now, with what has been proposed, because my understanding is that these trucks cannot automatically be rerouted. They need to be studied of how to do it. That's going to take a little bit of time. And with that plan already in place, should it be necessary, this board can act quickly to implement it. So with that said, I think that it's a good job done on that.
Did you put a date on that? Did I miss?
It was 45 days.
45 days, thank you.
Okay, are we done with that? The next page, I believe is 10.
The plan apparently, the franchise agreement has been awarded, hasn't it? Is that correct?
It's been
Mr.
awarded,
Bruin?
yes.
Yeah, we need to change F in that first sentence.
Mr. Lerner, if I may interrupt, it's been awarded but not signed,
Oh, okay,
so it's not,
not in stone, yeah,
the fat lady is not sung yet. We'd like to make sure that happens.
okay. You know,
On page 10, line 16. Well, let me back up. Starting on page 9, under agreement, there's a series of things that are to happen, but there does not seem to be a reporting of those events having been achieved, unless it appears elsewhere. I think it's needed. You might consider it being added in line 16 after the word respondent. So it would read, respondent shall report the above increments of progress to the executive officer.
Oh, line 16 on page 10, is that what you're
10.
saying? Oh, okay, I was looking on 9.
10, line 16. Well, if you go back to page 9, there's a number of things that have to happen at after certain times. So I'm just proposing a reporting step.
I like it. Can you say it again? Because I
No, I
don't.
can't.
You try.
Can the writers?
We could add one sentence which indicates that we will report to the executive officer and hearing board on each of the increments of progress
Thank you.
described in these sections on the food waste diversion. So we could cover the Chino facility and the American Waste facility in one fell swoop with one sentence.
What's an increment?
And where would that be inserted then?
Well, you could put it, I'm thinking you could just put it in, where, on page 13, where there's a subparagraph called J. Actually, I just realized it's in I. It says,
Yeah, okay,
I think we've got it covered already.
covered, yeah. Thank you.
Wait, on page 13?
Page 13, I, line 14.
Oh, okay.
Okay, that takes care of that. I'm still on page 12 now. On line 14, there's a date by which a petition to modify the order should be submitted no later than. That's nice, but it really needs to be submitted no later than June 10th in order to make sure that we get the item noticed so that we can have a hearing before the deadline.
I'm sorry, which line are you on?
Okay. Line 14, page
Oh,
12.
okay.
You see at the top on line 9, it starts out that if respondents unable to achieve the required diversion by July 1st to file a petition for modification by June 10th, we really need it a few days earlier.
Mr. Chairman,
Yes, sir.
could we revisit line 5 on page 10, I,
What page?
10,
Page 10.
I. Mr. Bruin mentioned I covered the area that we were talking about reporting.
He was talking about a different page. He's talking about I on page, wait, which page was
It was
it?
page 13.
Page 13.
It says respondent shall submit quarterly reports.
The 10, or was it I? Oh, page 13, not 10?
Page 13, line 18, on page 13. It talks about us submitting quarterly reports to the hearing board and the executive officer.
Sounds good.
That was line 14.
Page 13 starts at line 18 on my copy.
Line 18 or line 14? 14.
14 to 18.
I must be looking at a different version of the
If
order.
you're looking at the red line versus the green, that's the difference, Tom.
Oh,
We're agreed it's 14. Ms. Prusak?
If we're done with the specifics,
Mr. Bruin, do you see where we are? Because I think you got a different copy.
well, the I says in my copy, respondent shall submit quarterly reports to the executive officer, et cetera.
Yes, yes,
That's what I'm looking at.
Yeah.
yeah.
Okay, page, Ms. Prusak?
I just wanted to make a general comment since I just wanted to go back and forth between specific lines and deliberation because we never talked about this specific section of the proposed stipulated order, and that's just all this diversion. And I know that there's been a lot of issues that have been raised by myself and other members of the board with regard to the fact that this was sort of intended as the more scalpel approach to just restriction of tonnage, but that it's so far out. That's one of the things. And I just wanted to say that I feel comfortable with that as part of the overall order, especially now that we're seeing the delay being agreed to by both parties in terms of the 9 o'clock delay, including the City of LA trucks, and we're going to be seeing, as a result, a diversion of organics much earlier than we would here and in a more meaningful way. So overall, as part of that, I feel comfortable that these are good measures for the longer term. And then I also had an issue I wanted to raise and say why I feel comfortable with it. That in every single one of these particular provisions, there is a condition that states that if respondent is unable to achieve the required diversion, they submit a status report. But I feel comfortable after the conversation we had the other day with both parties agreeing that they understand that that is not an off-the-hook provision, that if the diversions that are required in here are not met it is a violation and that these particular provisions and conditions merely open up a discussion for alternatives that might occur. And I just want to make sure that I'm understanding that that is the understanding of both parties, but.
It's my understanding it wouldn't be a violation if there's a modification.
Right.
Or if we have another way of achieving the same means and we can demonstrate that, but that would obviously be up to the hearing board to determine.
Correct, and that also comes later in another provision, the alternative means. But with that understanding, I feel comfortable with these provisions.
For the record, the district agrees with that description. I just wanted to make clear what the chairman was, I think he changed a date with his last correction. Did I miss?
Did I?
You said June 10th?
Yes, okay, yeah.
So that is on page 12, line 14, you're changing June 15th to June 10th?
Yes.
Okay, thank you.
Okay, anything on page 13 more? What?
Wait, did we get all the way to 13?
Yep.
Okay,
Page 14.
Excuse me, line 25, at least 10 will become now at least 20. That's what we.
Line 25 where? What page?
Page 14.
Dr. Learn, if I could comment on that. Because we're going up to 20, feel a little uncomfortable saying minimum because we're starting to encroach on the intermediate cover enhancement program if we do any more. We cleared the 20 with Mr. Sung, so I just wouldn't want to create the impression of the public that we're going to do a lot more than 20. I mean, we might do a couple more, but I think it would be better if it just simply said 20 grids rather than a minimum of 20 grids, if that's acceptable.
Just clarification, grids and cover areas are the same thing.
Well, a grid is defined as about 1.1 acres. It's a,
The only reason why I say that is because 8 refers not to grids, but to intermediate cover areas. Should it refer to grids?
It's used interchangeably, the references.
That was the clarification I was
it
looking
goes
for.
on to say designated as surface monitoring grid, so I think
In
it's.
parentheses.
Okay.
So how would that read then?
It would simply say that respondent shall upon issuance of the order apply additional soil cover on 20 intermediate cover areas.
Ed? You had a conversation with Dr. Mr. Sully?
Correct.
And did he say 20 was okay or a minimum of 20, just to get this thing resolved? Or he didn't say, he just said 20 is okay?
May I propose 20 or more? That way it allows for more without, as Mr. Bruin points out, setting up some expectation that they are only doing the minimum if they do 20.
I prefer I'd rather stick with the minimum, actually. 20 or more is,
20 is what Mr. Sang represented he was comfortable with because that is the question that we presented to him. There was no specific language about at minimum, at least, et cetera.
we can keep the minimum so long as I've stated on the record that I'm not anticipating we're going to do a significant number above 20. How's that? So we'll just change 10 to 20 and leave it at that?
I'm sorry, but with taking, right.
Leaving minimum in.
Leaving minimum?
I was retracting my comment because I didn't want to agree to 20 or more. So we'll just make it 20 instead of 10.
Mr. Chairman, you alerted me when you went back to page 12 and you changed June 15th to June 10th. That addresses the American Transfer Station. That would divert food waste. That's what it is. That's the subject matter. We covered it. And what I don't understand is that you can't deliver the service that you're saying you will, but for that date, unless you get permits to build a building. The building is not built right?
Correct, we'd have to get it
You
designed,
gotta get
permitted.
designed and built and so on. So you can't meet a delivery date by June 10th, 2017, because it may not be built. You need permits, you need all that.
I think you're mixing conditions, Senator. The American Transfer Station timelines start on page 10. The deadline of June 10th, that applies to the transloading program, which starts on the bottom of page 11. So that is a different program for different facilities.
And what about the transfer station program? You got dates, same dates, June 32, 2017, 2019. Shall anticipate will not be able to divert 250 tons. Looking at line 11, line 15, I mean, page 11, line 15, you're asking too much of yourself that you may not be able to, that's out of your control.
We were beaten about the head and shoulders by Air District Council to agree to finite timelines that this board could enforce with respect to this facility. And if we can't make those deadlines, we have to show good cause why something has occurred that prevents us. It was the District Council's desire to have an enforceable order with respect to the operation of these facilities rather than leave it open-ended.
But you know that you got to design it, got to get an architect, you got to go out and bid, you got to get it signed off and approved by the city or wherever it's going to be located. Then you got to get it built, we got construction time. So you're giving us something that you have to come back and say, I'm not able to meet that schedule. So you do it as soon as possible. Well, okay, fine.
Ms. Byrd, and then Dr. Lerner.
Yeah, is there any way of expediting this on the grounds of the problem that we're faced with, as opposed to just building something, a commercial building for the purposes of doing X, as opposed to the purposes for which we're all here today?
Well, I think this order is quite specific as to what the purpose of this facility
No,
is. And it is an aggressive timeline, but it's one we ought to be able to meet with a design build firm that we're familiar with. So obviously there's a chance there may be a hitch in getting a permit or something like that. There's a force majeure clause in the order to account for that, but we'd have to go before the board and say, we've run into a problem and we need a little more time. But the idea is to keep our feet to the fire, so to speak.
Okay.
No, what I'm asking is there a role for expediting, in other words, going to the front of the line to get the permit?
Right.
Because of the issues that are before the board right now, as opposed to just a commercial venture, which can be at the back of the line, because there's no real.
I believe
Is there a role for getting an expedited permit?
I can just address Dr. Lerner. If you look on page 11, starting at line 10, it indicates respondent shall, for each permit application or other necessary approval, request and pay for expedited processing when available.
Gotcha. Thank you.
I want to alert the board. The other matter that is waiting, we'll either have to, we need to finish this one today. The other matter that is waiting that is also urgent and health-related, we'll either have to work late tonight or come in tomorrow. Okay, yes, ma'am.
Okay. No, throughout the document, it's pretty consistent with saying the number of days and calling them business days. But on that same page on 11, line 27, I just wanted to assure that that was intended to be within 30 days and not within 30 business days.
Calendar days.
That's calendar days, yeah.
Okay, you insert calendar days?
I tried to make the designation where I think it was appropriate, and so if it
Okay,
was,
if it's not there, then you didn't intend it. Okay. And just one little teeny tiny thing. Line 26, waster,
What page are we on?
waste, right? Okay, thank you.
I missed one. Page 11. Line 26. Just a typo.
Thank you.
Okay, we've done 11, 12, 13?
No,
No?
wait, we were up to 14.
We're up to 14.
We had skipped that.
Okay, yes, the minimum of 20. 15.
Okay, this is where a number, wait. Yes, number 10, where the parties have agreed to include language to the effect of the parties shall return for a modification hearing. And we don't have to say on a certain date because we're going to set it later on in the order, to set an expeditious schedule to enhance the entire surface area of the intermediate cover area of the landfill. Wait,
Ms. Prusik, might I comment?
better way to say that.
The testimony from Mr. Sung is that not all of the intermediate cover areas need enhancement. There are some areas that are perfectly fine, and we don't want to disturb them. His testimony was the areas that needed enhancement were those affected by the county soil requirement. But, this is something that will be a recommendation of the LEA study. And so I think we leave it up to that study to determine to what extent intermediate cover in different areas of landfill needs to be enhanced.
Okay, it's my understanding that the parties do agree to a provision in here, to wording in here, that specifies that at the return, an expeditious schedule to enhance.
Correct.
Okay, so what language, short of the entire surface area of the intermediate cover, makes sense?
Well, you could simply say those areas of those intermediate cover areas that the ICE program recommends be enhanced.
And does that make sense to the district?
Yes.
And I guess to the rest of the board?
Yes.
Okay.
Could we have
so-
done this 3 months ago?
What?
Okay, so then at the end of 10, sorry, I'm writing on so many different
You're
copies.
talking about paragraph 10.
Yes, I'm sorry, I'm just writing on so many different copies. Okay, so at the end of paragraph number 10, it will say, "The parties shall return for a modification hearing to set an expeditious," how about, "The parties shall, at the modification hearing, set an expeditious schedule to enhance those intermediate cover areas the ICE program," can't read my right, "recommends be enhanced."
Do you mean status hearing, Ms. Prusak?
Yes.
What page are you on, Julie?
I am on page 15, number 10, at the very end. I'm adding this. Okay, so it's shall at the status hearing, set an expeditious schedule, et cetera, et cetera.
Anything else on page 15? Page 16, line 12. There's a word will that I think should be shall. Line 19, page 16.
Page what?
Page 16,
Okay.
line 19. It says described in section 9. And I don't And I think section 9 does not, I think something else.
I believe it should be section 11, because that's talking about the dewatering program.
Thank you. Anything else? Oh, yeah, I do have another. On line 26, page 16, that evil word will appears again and should be shall. Line 26, page 16. Anything else on page 16? Page 17. I have a question on line 13. If the word loading appears, should that be unloading? It should be unloading? Yeah, I had to read it a dozen times.
What line is this, sir?
Line, on page 17,
Line what?
line 13,
Thank you, sir.
loading should be unloading. Page 18, Ms. Brusette?
I just, I wanted to, again, deliberate or discuss some issues or some things just to point out about this particular section, and then it goes, and then I think there's another one that's like it. But this idea of respondents submitting to the district for review and approval, the issuance of, a proposal for additional best management practices to supplement the existing practices. And I know that there was some concern among the some people who testified regarding the wording, such proposal shall consider and evaluate, but I wanted to, and I also had concern as to whether what was enforceable, what would happen in the situation where the district wanted a particular enhancement and there was a disagreement. And so I just wanted to point out, I don't know where it is now, but it was on page 19, but under general conditions, it's still on page 19, and it's still general condition number 2, that the respondent shall immediately contact the district should the district's review of any respondent submissions required hereunder cause the district to conclude in writing that additional measures are necessary at the landfill to control odors, and respondent is unable to agree to such measures, such notice shall describe the reasons for the infeasibility of the provisions or other concerns with the provision. Respondent shall endeavor to resolve the infeasibility with the executive officer of it, or is that, oh, it says of, it should say or, so, but we'll get there. Or his designee. If the feasibility of the provision cannot be resolved, respondent shall petition the hearing board for further proceedings. Such proceedings shall be limited to a hearing on the imposition of the measure or measures described in the notice to the district as infeasible or otherwise problematic. And it was discussed and questioned whether that relates to this particular report, and it does. And so I'm very satisfied that there is a good procedure in place to make sure that the best measures are adopted or come before this board for a hearing.
I hear no comment. So everybody's good on that. Page 18. Page 19. I have an item on that. Page 19, line 15. Sentence says, if the inconsistency cannot be resolved, respondent shall notice a hearing. board notices the hearing. So respondents should petition the hearing for a hearing. Page 19, line 15, toward the end of that line. Anything else on that page? Yes.
I don't have anything in particular on this page, except for the one we just found, which was on line 23, the executive officer, it says of his designee, it should say or. But I'm not sure if this is the place or if there is another place, but the parties have agreed in lieu of a cap at this time to produce status reports, I will hope on a monthly basis, if that's possible, on tonnage. And I would like to ask not only, that be given to the board and to the executive officer, but is it possible to also, in that report, provide the board and the executive officer with estimated tonnage that is diverted as a result of the delayed opening for the transfer trucks?
We can endeavor to do that.
Okay.
And the first report would be due at the end of the first full month after the order is issued, so that would be end of January.
Mr. Chairman, let's go back to this general condition. The inconsistency that they're talking about is that if the other agency is making one requirement upon this operator, and it cannot be agreed upon, that's going to be defined as an inconsistency. Is that right, Mr. Bruin?
I'm sorry, Senator, I didn't hear the question.
If the other agencies are, like the city, the county, planning, Los Angeles Planning Department, City of Los Angeles, conditions of this order shall not be in any way restrictive to expanding the scope of jurisdiction of any agency. There may be something in this order that might do that. And if you reach an inconsistency, you're saying that you should come back to the board and notify the board. Is that correct?
Correct.
And if the inconsistency is not accepted by that local government agency, then what should be the position?
Well, I think the concept is you can't force government agencies to agree with each other, but the idea is to create a process that will hopefully cause them to agree. And I think this abatement order is evidence that we've succeeded in this abatement order to get concurrence of the agency. So I'm hopeful that providing a process for agencies to air their differences will give us a way to resolve any differences that might arise.
Well, there is some notice of violations issued by the county already, regional planning or public works, and that has not been resolved, and you always stated you're in discussion with them currently on those issues, and you have not come to any agreement. And nothing in this report suggests that you have, but you will. So we have an inconsistency already.
I don't believe there's any inconsistency with the notices the county has sent us in this abatement order. We do think we have a resolution on the one notice of violation, and we're working with the Department of Public Works on that issue.
Mr. Bruckman's letter is very strong. You probably should read it, because they're gonna dig their feet in. If they dig in, then nothing's gonna happen, unfortunately, if that becomes the case.
This order is binding on us regardless of what the Department of Public Health might do.
Yeah.
If they do something more stringent, we'll have to deal with that at the time, but we're not expecting that.
Okay. Wish you luck.
Thank you.
I don't think so.
You were trying to determine
The end of January, you had said.
Yeah,
perhaps.
end of January.
Do we have a date? Can we think of a date? So for the first month would be, right, so if this is taking effect immediately, then it would be, well,
How about February 1?
Okay,
So
let's
we
do
have
that.
that's an easy date to remember. And every month thereafter, we'll give you a tonnage report with estimated tonnage diverted. Although we may not know that precise number, we're going to estimate it, obviously.
right, that's why I would like to see estimated tonnage diverted. And just as a point on this, I wanted to see a cap. I think a cap is really important for all the reasons why I discussed. However, there has been a representation made that the tonnage, and we've seen it on charts before, has remained relatively the same, and that there is no anticipation that it will go up, that it should remain relatively the same. So these monthly tonnage reports, as was suggested and an alternative put forth by the parties, by Republic, is a way to monitor that and make sure that it is occurring. And if not, this board always has the opportunity and option to modify its own order, and in fact, it says so specifically on page 20. So I just wanted to say why it is that I accept that as an alternative.
I have one final edit. Or,
Mr. Chairman.
just a second, let me.
On page 20, line 20. It says the end, and I agree.
Of what? But it wasn't the end, because I still have one item that you didn't let me cover. On page 19, twice there is indication of a individual to be reported to, and I think there we also need the words "or his designee," because people shift around within the organization.
I was going to propose, Mr. Chairman, that also just to make it simple, on the bottom of page 19, just change Dr. Tosopoulos to my name and my email. I was going to volunteer Miss Manwaring, but I'll keep my name there.
I was going to volunteer Ms. Reichert.
Because she's not here. Ms. Prusak.
I just wanted to clarify for the record that the new condition regarding the monthly tonnage reports, the first of which will be due February 1st, will be, I think should be paragraph 3. Numbered paragraph 3.
That's
That
fine.
makes sense. And then renumber after that.
Okay.
Then we need a return date.
Yeah, I'm thinking maybe the end of February.
So we need 2 months for, if we want to make this work for everything, we would have about 2 months for the intermediate cover, was what Mr. Singh anticipated. He could have that enhancement project, the report in by, and 45 days we need to, which is less than that, 45 days for the proposal with regard to the local route trucks. So 2 months, whatever that, right? Does that make sense?
2 months, yeah.
So is that the end of February,
15.
beginning of March?
The end of the month of February. That's,
If we have
gives
available
time to prepare. Pardon?
That makes sense to me.
Okay.
February 28th?
Is what day of the week?
I'm sorry.
I got one of these dandy devices.
The district would propose March 1st.
March 1st is good. It's a Wednesday. Anything further? I started.
Proposed from the caption.
Proposed. Oh. Okay. Now, on the footer all the way through. Ms. Prusek, would you like the honor? Or dishonor?
I could do so. In the matter of South Coast Air Quality Management District versus Browning Ferris Industries of California, etc., case number 3448-14, I move that we grant the stipulated order for abatement that is found in Exhibit 40 with all of the modifications that have been detailed, and for the sake of time, I apologize to the clerk. I am not going to detail them all. However, I'll make myself available to go over it with her, whoever it is, and to do so for good cause. And we've talked a lot about what is good cause and what we feel will be effective and not effective, but I feel, well, that's the end of my motion, but I just wanted to explain.
I'll second the motion.
Thank you. And I wanted to explain that I do think that with the changes that were made, we can expect short-term, immediate impacts and long-term impacts. And we are all crossing our fingers, and nobody knows that this will be as effective as we hope it will be. However, we have set a very soon time for this board to reconvene and to see what the effect is, and to make modifications should they be necessary. But I think we are at the point where this is the best effort we can put forward based on the testimony we've received, the parties' input. Again, with my thanks for responding to our issues, and let's hope we don't have to modify too much and that it is effective.
Mr. Chairman, I was just informed that our monthly tonnage reports aren't compiled until 15 days after the prior month. So if we could have an understanding that we would provide you with a report on the 15th of the month following the month in question, I would appreciate that.
So let's have the first one due then on January 15th, because it would be part of the month of December, and that way we have a starting point.
Okay.
That's fine.
I'll accept that change. Motion's been made and seconded. Discussion, board members.
I just had a couple comments, and I just wanted to quickly commend the staff for all the emails that I received in the evenings and weekends. It meant that you were working as well as the board, and that I believe that this is a comprehensive order, and Mr. Sang has indicated that we should see some results in the next 2 to 3 months, so we're looking forward to that being the case, maybe by the time we have our comeback.
Anyone else? I'll put it to a vote. Dr. Lerner, how do you vote?
In favor.
Ms. Byrd?
Yes.
Senator, how do you vote?
I put the motion.
Holden, no to aye.
Thank you, Holden. Motion passes 5-0. I would like to commend not only the, well, first of all, the attorneys. It was quite contentious at times, but everybody was professional. It was contentious at times. The public was professional. And I also would like to express my appreciation to my fellow board members who took in a lot of information and made some sense of it, asked a lot of questions, pushed hard, and we got some good concessions. Thank you very much. Good luck.
Thank you, Mr. Chairman. Members of the hearing board.
You're right, I went from no to aye.
Board members, we have need to take a brief recess, and let's reconvene at 10 minutes to 3. The next matter is equally important. And we either need to stay late or come in tomorrow. So,
Do you want comments
Yeah.
regarding that? I would prefer to come tomorrow, but that would be my preference because I have a feeling staying late will not complete this anyway. So I
the
would
brain
prefer
is
to
kind
come
of
tomorrow.
frazzled. Yeah, me too.
We're not on the record. And I would,
We're back on the record. Sure. Good afternoon. We'll now take up the next matter, Aircraft Heat Treating Company, Inc., and Anaplex Corporation, case 6066-1. Who's representing Executive Officer?
William Wong on behalf of the Executive Officer.
And representing Aircraft?
Ivan Tether for Aircraft. And Tom Wood for Aircraft.
Thank you. We proceeded with a bifurcation of this hearing. So Anaplex is essentially not a part of this hearing, am I right?
Well, we've asked them to be present. I believe they are. We can.
Well, as far as not a party to the to what is being considered.
That should be correct. Yes.
Excuse me, I have something to say about that, Mr. Chairman. I'm sorry for interrupting.
You're Mr.
I'm sorry. This is William Thunderberg.
For
Anaplex Corporation.
Thank you.
William Thunderberg for Anaplex Corporation.
Go ahead.
Thank you. As Mr. Castillon informed the chair and the esteemed counselor on the hearing board this morning, Anaplex received a request to submit a response to the Aircraft stipulated judgment that was made available to the public and to Anaplex yesterday, and they received that request yesterday evening, and Anaplex responded this morning at around 9:45 and sent the response to Mr. Wong. As Mr. Castillon explained this morning, Anaplex, the reason that Anaplex did file its motion to continue with this board was because Anaplex had not received documents, and there was a pattern that had developed that Anaplex, despite the fact that Anaplex has been cooperative and reducing chromium emissions from its site, had tried to work on two tracks. Anaplex also, as Mr. Castillon represented at the hearing yesterday, is a 70-person company and does have the resources. They have a new team to monitor environmental, but they execute it as it was indicated in the motion to continue. But Anaplex does not have significant capacity behind it to engage in just multi-track disputes. So the
that's the reason that Aniplex submitted the continuance. In this case, Aniplex also asked that the cases be unjoined, and Aniplex believes that, and would like to restate its request, that the Air District should refile its petition for abatement, because right now, even though there's a ruling by the hearing board that there is a bifurcation, they're not separate complaints right now on the record. There are no separate complaints, and Aniplex is still joined with Aircraft. And so the most interesting thing to note that Aniplex would like to put on the record is that Aniplex learned just today that there was a separate side deal between Aircraft and the district. And Aniplex learned today that Aircraft's theory is that Aniplex is the cause of the emissions at monitoring station number 8. And that was the reason that the settlement for Aircraft could not go forward without Aniplex. So the reason that we're coming here is just to restate the motion to continue, but emphatically raise the point of the prejudice that takes place. If the district wants to pursue a separate action, then they should file a separate petition. That would unhitch the actions. Right now, they're hitched by the petition. The hearing board has made a ruling ostensibly bifurcating them, but what in actuality has happened is information that Aniplex would like to put on for its case is not being made available to it. There have been numerous requests made. There has been some exhibits and some documents that were provided. The inspector reports for 2016, none, 0. This is truly this is a company that is trying to do the right thing. It is simply trying to do the right thing by the community and by its employee owners. And it is not a small business that's just skirting environmental regulations. I have represented those, and I know what they're like. In my 25 years, I haven't seen a more committed company from the employee end that has done this. So I want to restate that, and that's why I'm here today. And I didn't mean to be disruptive or anything, but there's simply what we believe to be conflating of the technical issues, potentially on the legal side. We didn't know what witnesses were going to be put on, so we didn't know whether to show up with rebuttal witnesses. I was in a settlement conference myself this morning while the pre-hearing conference was going on, so excuse me if I'm getting anything wrong from the pre-hearing conference. I am just going from notes, and I might have misheard something, and I do deeply apologize to you. As a public servant myself, I understand the commitment that you all make to doing what you do and putting up with and overseeing, making sure the charge of the district is met. So I'll make myself available also for settlement discussions, which is something that was talked about this morning. But I wanted to make sure that this got in, and we were unsure whether Sunshine was going to go forward or not, or what the timing of it was. So I was just camped out outside. The company CEO is having whom you haven't not met, Carmen Campbell, is in a board meeting with the company because obviously this is something that the company is taking seriously. So the changes, including the ones that were proposed this morning to Mr. Wong, are being considered, and further additional information will be forthcoming to Mr. Wong related to trying to get that resolved as soon as possible. Regardless, Aniplex is implementing measures today that it wasn't implementing 7 or 14 days ago, intended to protect the public, because that's what this is about, regardless whether there's a dispute as to where the public is and where it's not. So I just wanted to make that statement. I appreciate the courtesy of being allowed to sit here. I respect the ruling, but I would ask to be allowed to sit here to cross-examine any witnesses that are being put on to approve the settlement. There are specific issues that are being put on related to data from monitors 8 and 15 at the sites that we just can't add up based on whether Anaplex is the cause of the aerocraft emissions. We can't add it up. And maybe we were told that there was some data. We haven't seen it. There's other data that we haven't seen. And a settlement is about to be approved where the standard is being set that can be used against Anaplex, and Anaplex doesn't have the right to cross-examine. It doesn't, on its face, seem fair, although we understand that this hearing board is charged with looking out for the public and the citizens of Paramount. So Anaplex is doing the right thing and making changes as we speak in accordance with the promises that were made related to the motion for continuance. One last thing, and I'll let the counselor go. I know it sounds like she. One last thing is there are a couple of facts in the motion for continuance. I just want to put it on the record that were misstated, and I want to make sure that you probably knew they were wrong, but the Hickson is not a metal a chrome plater, as you know. You've heard it many times, and so I want to make sure that that was brought to your attention before somebody else did, that was done. But the point in the contrasting Anaplex's operation with Hickson, at least according to the consultant overseeing Hickson, is that the operations for Hickson are much more expansive, and it's located next to a condo complex. So I thank you for the opportunity to be heard, and we would like to examine the witnesses. And we just received this. I don't know if this has this ideal or whatever that hitches Anaplex performance potentially with aircrafts, or if Mr. Castellon misunderstood that. But I haven't even read this, and we just received it. And
What is it you have?
this says findings and decision for order on for abatement stipulated.
Okay.
So, I don't know if it's the same one or the one on the call at the pre-hearing conference this morning. Mr. Castellon said that or it seemed to be represented that there was something separate from what was made available to us yesterday that related the Anaplex performance to aircraft.
Okay, we'll clarify that shortly, but before I give Ms. Prusak and Mr. Wong an opportunity to respond, and perhaps Mr. Tether, I want to address the members of the public who are here. First of all, I want to apologize. We did set the hearing to start at 1 o'clock because we anticipated completing the prior case. It's called Sunshine Canyon Landfill by noon, and so that we could have time to start this hearing on aircraft. We finally concluded that at about 2:30, 2:40 this afternoon, after 16 days of hearings, after probably 70 different witnesses, expert witnesses, and a stack of paper that high, exhibits, documents, petitions, responses. That was a very difficult matter that involved a lot of members of the public who were aggrieved about the emissions from a landfill that they had been exposed to for many, many years. This problem is no different. Maybe it's a different kind of emission that we're going to look at, but it is a situation where there are many members of the public affected. At least that's the allegation. And what I'm getting to is we're not going to finish today. There's no way that we can provide for a fair hearing, and that's my job, to make sure everybody is heard, that when you walk out the door and we've made a decision that this board has heard everybody, considered all the facts, and made the wisest decision it can. And so we're not going to finish today. Problem is, do we go to tomorrow? We already have one board member who had to leave because he showed up quite ill. And he just, he should not have showed up this morning. And I don't think we can, I don't know that we can have a we can continue to next Tuesday, because I don't know what Mr. Wong's schedule is, or that of the party. So we're gonna, before we end at 4, we're going to have to decide what is the next day for a hearing. Okay, with that, Mr. Wong.
Thank you, Chair and the remainder of the hearing board. I do want to congratulate you on your fine work with Sunshine Canyon. I do agree that that was a very extended effort, and you, all 5 of you, did an excellent job in reaching a decision. So my congratulations to you. Turning to this case and your question about continuance, I unfortunately am unavailable next week, but we can do it for tomorrow morning. Unfortunately, I have a root canal scheduled, and and I need to leave at 12:30, and I think Ian may have to leave a bit earlier, but I am available tomorrow morning. Speaking to the Mr. Funderburg's complaint, this is not Anaplex's hearing at this moment. I mean, he's re-argued his motion for continuance, and he certainly is welcome to do that at the time when we are hearing about Anaplex. But the cases have been bifurcated, and he is not entitled to cross-examine our witness for the purposes of the aircraft's stipulated order for abatement. I'm a little confused about some of the things he said. We did not request any comments from him about aircraft stipulated order for abatement. What I did receive this morning was a communication by email from their client wishing for a Word version of the aircraft stipulated order. And my assumption at that time...
Excuse me, Mr. Wong, I'm sorry to interrupt you, but just to get the facts right, and this is in writing, that was requested yesterday evening, not this morning. Okay?
No.
Excuse me, sir. Let's let Mr. Wong finish.
Right. So this morning, I did receive a request from one of your members of the thing. They wanted a Word version of the order for abatement. And I've provided that to him, which may be what he is talking about, and with the idea that perhaps he was actually trying to fine-tune a stipulated order for abatement for purposes of Anaplex, but I guess that is not the case. At the pre-hearing conference, we did invite Anaplex to come down to resolve the potential for a stipulated order for abatement. And Mr. Funderburg is here, and he actually did engage some talk about it. But he was not invited to participate at this particular hearing regarding aircraft's stipulated order for abatement. So we would object to his participation in the stipulated order for abatement.
He'll be a member of the public since this
He can be a member of the public.
Could I make one response, Mr. Chairman?
Not yet.
Okay.
But you'll be given an opportunity. Mr. Wong, if some of what Mr. Funderburg is bringing up, he's suggesting a separate case, which would, I think, a separate petition, which would be a problem because that means that we would have to notice that hearing.
Right.
And it being a order for abatement, the publish notice would take time.
Yeah, I agree. And I also oppose his request for a separate complaint simply because the complaint is written so that it separately spells out what the concerns are with Anaplex. And again, we do pretend to add any DOEs that come on that we may find as future sources of the hex chrome, because the hex chrome is a universal problem for Paramount. It's not just one and one, it is accumulation of sources. And the reason for the kind of group order for abatement, if you want to describe it that way, is to try to resolve all the issues in the city of Paramount with respect to significant sources of hex chrome. Mr. Funderburg also complained about documents. I have no idea what documents he's talking about. He may have made requests for documents to engineering or compliance, but no requests have been directed to me. So I have no idea how it relates to this case. So,
As far as you know, there's been no request for, under the Public Information?
not that is there? There was a Public Records Act request for information.
Do you know if that's been satisfied?
I don't know. I don't know. But again, there's been no specific request for documents from me.
Ms. Prusak?
May I just say, along the lines of requests for documents, all of that, those were part of the arguments made for continuance. And for the benefit of those who were not in the pre-hearing conference this morning, we had discussed an order for this case, which would have us hearing the case now first on, it's been a long day, Aerocraft. I want to call them aerospace all the time. Aerocraft, although we'll hear about this from the parties, but there's a little glitch in terms of the fact that we learned for the first time that it's not the order in full that they would like us to grant. Well, they would have liked it today, not today. But we're going to have to hear about that from the parties. But then as the second point of order, once that is completed, we should hear the motion on the continuance by Anaplex, and that is because, with good reason, I know there were things brought up at the pre-hearing conference that were new, that Mr. Castillon then reasserted the objections once again, and the request again for a continuance. So we had decided that that should be heard because it's tabled, but then it comes back, and let's just hear it. As far as sitting in and questioning witnesses, the request is to separate these matters out, and the motion was made by the board to bifurcate. And what we meant and what we ordered as part of that was that any evidence that is presented during Aerocraft's portion of the proceedings will not be used against Anaplex. Cannot be and will not be, because Anaplex will not then be able to cross-examine the witnesses. And that is usual practice. So I would suggest proceeding as we had anticipated, Anaplex not questioning the witnesses, but any evidence will not be used against Anaplex until Anaplex has an opportunity to question any witnesses.
That raises the next question. When what we've got before us is not only Aircraft and Anaplex, but those 1 through 100. When one of those comes up, they will not have had the opportunity to cross-examine witnesses, and so for each one of those, will we have to go through the same process as we apparently now will have to go through for Anaplex?
Yes, and I think it makes sense because for every DOE, for Anaplex, for Aircraft, we need to make different findings. The findings need to tie, unless there's a stipulated order, we need to find that they are a source of the problem, and we're going to need to tie that back. And so that has to be done individually for each party that comes before us, when and if they do.
Okay. Inasmuch as we're ready to start with aircraft and the matter is bifurcated, at what point in time do we rule on the continuance? That is now or when we complete the aircraft matter?
I might suggest we wait because I think there's an urgency, and that's why Mr. Wong and Mr. Tether and Mr. Wood are here and available to discuss this order because they want something in place, but now I'm a little confused as to what it is, but I think we'll hear what it is. And I think that Anaplex will be happy to wait for that because it gives them an automatic continuance. However, the only question I still have is if we're saying that Anaplex need not be present while aircraft's portion of the bifurcated hearing moves forward, how will we alert aircraft when they need to come in for a continued hearing to hear the motion and then ultimately what we decide? So that remains.
Could I make a comment on that, Chairman Camarino?
Quickly.
Yes. I think that the counselor brings up a very good point related to the ability to cross-examine the availability of the aircraft witnesses. And it goes to really the public and what the information that's being afforded the public as to whether they are, being afforded the opportunity. I think the hearing board can make a better decision if the aircraft is allowed to cross-examine these witnesses. The information that aircraft has, for instance, when aircraft has wind roses that it believes rebuts some of the testimony that will be presented today, which aircraft doesn't even know, which Anaplex does not even know because Anaplex doesn't even have the data related to the difference between wind monitoring station 8 and monitoring station 15 beyond one or two single points that have been taken over the past 2 months. There is data out there that has not been shared with Anaplex that's being used that could potentially prejudice Anaplex. And the public, not Anaplex, but the public deserves the right to hear this settlement clearly between Anaplex and SCAQMD was being worked on for many weeks or whatever before the petition for abatement was filed. Anaplex is a tiny company, doesn't have the resources to conduct triple track negotiations. And so Anaplex didn't even bring counsel in. That's their responsibility, but they didn't even bring counsel in until right before the petition for abatement was served on them. So in terms of the information that Anaplex can make available to the public, there's that. Then the point being that the public should be afforded having the information upon which to make a decision as to whether to approve this. And the data is important. I don't know what to compare Paramount to, but I haven't seen much like it because there are so many multiple sources. And Anaplex wants to own responsibility for what it did, but it wants to make sure that the framework is set up so that it can do that. And so Anaplex would like to, I'll restate it, I will remind the chair that the Anaplex offered to withdraw its motion for continuance, so it's not dragging its feet. Offered to withdraw its motion for continuance as part of the resolution to this matter and put up fence line monitors at 1 nanogram per meter cubed within somewhere around 45 days. And so it's a matter of the time period, and we have to negotiate that with the district.
May I just interject here? I know he doesn't want to delay, but he seems to be doing the exact thing. He's re-arguing points. And there's really no need to spend a lot of time.
Excuse me, Mr. Wong.
So, excuse me.
He interrupted.
Hold on.
Mr.
I know that he did. Okay. Let's just stop. Mr. Wong, let's let Mr. Funderbrook finish his comment.
Okay.
I'll call on you. And then, and briefly, it's
We are
3:20.
re-arguing
I understand.
the motion that was tabled, but that has been
understand.
requested to be reopened, now that things.
I understand. I just want it on the record. If you want to remove me, we object, and I will leave, okay? But I'm just saying that just for the record, that's what is put out there. we'll continue discussions with the district, Anaplex will, and hopefully there will be data forthcoming. We made public records requests contrary to what.
Okay.
Okay.
May I just say a few words?
Mr. Taylor.
Sorry to add to but first of all, we would reiterate and for Aerocraft also object to the cross-examine of witnesses by Anaplex. I'm feeling as though in some ways this is becoming more complex than it needs to. We are not necessarily casting stones at Anaplex. We are simply saying, and will present data that shows that there is a relationship between Anaplex's emissions and readings that are made outside Aerocraft. We're not saying that they're the cause completely of the problem, but we're saying that. And we're saying something that bears solely upon the timing of an order against Aerocraft. Nothing more.
We understand that.
Thank you.
Maybe I didn't understand, and I don't need a response from Mr. Funderbrook, but if he said that the data and evidence that Aircraft might bring forward is not available to Anaplex or the public, that's not right. All evidence that comes before this board is public information.
I just wanted to end the matter by saying, I'm not asking Mr. Funderburk to leave for any reason other than that the request was made by Anaplex to make these separate motions. That you've heard from the board, that is impractical because to extricate the two matters from the petition and refile would unduly delay this, and it's my belief as well that the petition itself is very clear in which applied to which. But we did the next best thing we could do, which was to bifurcate the matter. And in doing so, we are, and I'll make it clear one last time, anything brought up will only, in Aerocraft's matter or proceedings, will only apply to Aerocraft and our decision in Aerocraft. It will not apply to Anaplex unless it is presented during the bifurcated portion devoted to Anaplex. And Anaplex will have all the ability in the world to cross-examine and to dispute the evidence that is presented. And as the chairman stated, it is true, everything is done in the public before this board, so every piece of evidence that comes before this board will be made public.
Okay. Ms. Byrd?
This is not the first time that we have done a group order for abatement, and typically the first, there is one case that comes and the other does follow. We've never heard them all at the same time, have we?
I think they've always been stipulated.
They've always been stipulated.
And so the new ones just add on with a, I agree.
Okay.
All right, let's start then. Before the end of the day, we're going to have to decide when we continue this matter to. Mr. Wong?
Thank you, Mr. Chair and hearing board members.
I'm sorry, Mr. Chair, would you like me to leave because?
You can sit in the audience.
Okay, I don't want to interfere with the
You don't need to
proceeding,
leave.
I just want to make sure it's your ruling that you're denying our request to sit here.
Yes.
And, okay, on the record. Thank you.
Just one question, Mr. Wong.
Yes.
How is Anaplex going to be part of the scheduling of their portion of the bifurcated hearing if they are not sitting here in the room?
Well, if the board wishes to continue something specific for Anaplex, we will notify Anaplex.
Okay.
For the record, Mr. Funderbrook has left the room. He was not ordered to leave the room. He was not asked to leave the room. He was only asked to leave the dais or the table where the attorneys for Aircraft sit. Mr. Wong.
No, again, thank you very much. As I understood from the hearing, we are trying here to kind of really demonstrate the effectiveness of this order. We do not intend to bring on witnesses to demonstrated any nuisance or violation because we have stipulated to everything and we are just now addressing the order. We've submitted actually a new set of findings and decisions. We have eliminated Dr. Roger Lerner's identical twin brother from the petition so that he does not seem to be part of the case.
Does he feel bad? Okay, we have new proposed findings and decision in this matter, which we will mark as the next in order, which would be then exhibit number 12. You may proceed, Mr. Wong.
Thank you. We have a witness here, which I will have him go through the order, each paragraph, to explain to the board. And if there are any questions, you may direct it to Mr. Ian McMillan, and he will be happy to respond to it.
Thank you.
Yes, were you sworn in yesterday? He was sworn in yesterday, so
Those who will be testifying today, please rise to be sworn in. Raise your right hand. Do you promise to tell the truth, the whole truth, nothing but the truth, so help you God? Thank you.
Okay, thank you. Mr. McMillan, would you please state your name, spell your last name, and indicate your position with the district?
Yes, hello, my name is Ian McMillan, last name MacMillan. I'm a planning and rules manager here at the district, specifically for the AB 2588 program, the annual emissions reporting program, and some rulemaking.
And Mr. McMillan, did you work on this order for abatement that has been stipulated to by Aerocraft?
Yes.
Would you please go through each of the paragraphs, starting on paragraph 8, and explain by paragraph, the essential meaning of these orders and how it controls hex chrome emissions?
Sure, I think you meant page 8. We'll start at paragraph 1.
Right.
And I'll spend more time on the paragraphs that need it. So in this first paragraph, this is the one that actually has probably most of the meat, where this sets a limit of 1 nanogram per cubic meter as measured at a monitor that most represent Aerocraft's emissions. This 1 nanogram per cubic meter threshold is measured over the most recent 3 samples collected at that monitor. And what this says is that if that threshold is exceeded, then Aerocraft needs to curtail their operations and not operate any processes that might generate hexavalent chromium. The second portion of this paragraph deals with, it allows the district to have some discretion if there is information that is presented to us by Aerocraft or information that we have independently on our own that we believe there are certain processes at the facility that do not cause hexavalent chromium, that in an order for curtailment we can exclude those limited portions of their process. There's also a small point in here about the first 7 days of the order and how that averaging period is put in. So for the first 7 days, instead of a 1 nanogram per cubic meter, it's a 3.3 nanogram per cubic meter on any day. This equates to a 1 nanogram per cubic meter over a 7-day period. So it's just meant to be equivalent, but we aren't making it retroactive to before the order. I guess I'll ask, do you want me to keep going or through all of it and then questions at the end, or do you want to stop with each paragraph?
That's, I'll entertain questions from the board on this paragraph. Did you say retroactive?
What is the provision for the first 7 days?
Yes.
To have a different threshold is so that the order is not retroactive.
Oh, okay. Board members, questions on that? Ms. Prusay.
Can you just briefly explain the 1 nanogram level and why it is health protective?
Sure. The 1 nanogram level was set to be consistent with both the Hickson order as well as to be consistent with other Air District rules. So the 1 nanogram, when looking at the monitoring data, we found about a 5-fold difference between monitoring data just outside aircraft and the closest resident. About a 5-fold difference in concentration, that the concentrations are about 5 times lower at the closest resident, which is about 500 feet away. That 5-fold difference of 1.0 nanograms per cubic meter drops the residential level down to about 0.2 nanograms per cubic meter. That 0.2 is roughly equivalent to a cancer risk, a residential cancer risk of about 100 chances per million. That's roughly the same level that was used in the order for Hickson of about 100 chances per million was the target used in that order for abatement. In addition, there are district rules such as Rule 1402, the Toxic Hotspots Program, which has a significant risk level of 100 chances per million, and there's a district process for how to address facilities with that risk level.
Anyone else have a question? Thank you.
I'll move on to the second paragraph. This deals with aircraft at its discretion can operate its own monitor on its own property on using a sampling and analysis plan that is reviewed and approved by the district, and they can submit that information to the district for our consideration if we see that there is monitoring data that is above that threshold of 1 nanogram per cubic meter.
Ms. Byrd?
I'm sorry, you went through it before I finished reading it, but the significance of aircraft, is there, I see that there's a district-approved sampling and analysis plan, but is there any, will the district be also conducting sampling and analysis at the same time? I didn't get to the end of the paragraph. So
sure. This paragraph deals with a monitor that aircraft would operate on its own if they chose to do so. This is separate from a monitor that the district would operate on its own outside of aircraft's property that would be used for the 1 nanogram threshold comparison. So this would be a separate monitor that aircraft could place on their site that would provide additional information to inform the district if that 1 nanogram exceedance is coming from aircraft or potentially from another source.
okay, so this is only outside at the monitoring station that the district will be monitoring, but aircraft will be monitoring on site, inside their facility.
If they wish to.
And I see that the district shall consider their evidence in concluding whether or not the 1.0 nanogram per cubic meter has been exceeded.
Correct.
Okay. And when you say consider, those words always kind of catch me up. Exactly what does that mean? Does that mean from that point on, then you go in to confirm?
I think let me explain it maybe with an example. So say, for example, we have a monitor that we are using for this compliance of 1 nanogram that is downwind of the facility, immediately downwind of the facility. As an example, aircraft might decide to put in a monitor on the upwind side of their facility. And they say, look, the upwind side is actually a very high level, and it's coming from an upwind source potentially. The district should consider this when looking at what happened at the downwind monitor. And depending on not just that single piece of evidence, we would look at all the evidence before us, but that would be an additional piece of information for us to consider.
Okay, thank you.
Dr. Lerner?
Yes, I just want to be sure, aircraft is actually in control of the monitor on their within their property. It is not a third party, is that correct?
That is how this is written right now. It's their discretion and their monitor if they chose to bring in a third party. I don't know that this paragraph addresses that.
That's why I'm asking you. Okay, thank you.
I should say there is they do have to give us a sampling and analysis plan, and that does need to be approved by the district. So I imagine that will be part of that plan, and there will be some discussions on that.
Okay, we just got this document. Let's do what we should have done at the outset, and then I'll take a little time out, a few minutes, give the board members an opportunity to read it, and then we can hear your explanation with a little bit better understanding. Thank you.
Of course.
We're off the record. We're back on the record. Ms. Prusak has a question for Mr. McMillan.
So, just so I understand, so the 1.0 nanograms, that level, it's expected that they will be able to be under that level because of the measures in the factual section, paragraph 13? Is that?
Yes, that, and there may be other measures that they'd be implementing as well, as they learn more about the processes and what might be causing the higher levels.
Okay, and then, so it was your testimony that if it's 1.0 nanograms at the monitor, then at the residents that are the closest, it would be 0.2?
Approximately.
Nanogram, approximately. And then in the facts recitation, is it true that the basic typical background level is about 0.06 nanograms?
Approximately, yes.
So it would be, would you classify that as being significantly higher risk, the 0.2 nanograms? I don't know how that works versus the 0.06 nanograms. And so I want to start with that question. Is that?
Sure. The difference between the 0.2 and say background, there wasn't any attempt in this to take out background from the 1.0 or the 0.2 level that we were considering here. And again, that is also consistent with Hickson. Hickson, there was no subtracting of background levels. We recognize that there is some background that's there, but when looking at the difference between the closest monitor to aircraft and the residents, as I mentioned, that's about a 5-fold difference, but there is some fluctuation there. And so we felt that it was appropriate not to try to be too precise in backing out a background level when we're the fluctuation that is occurring there is still being we're still in the data collection stage. In some points, we're going to be continuing to collect data, and that number will be refined as they go through other processes like District Rule 1402.
Okay. I guess my underlying concern to those questions are, it was discussed that there is a cumulative effect, obviously, in Paramount. And so I'm wondering if it's your opinion that the measures that are listed in 13, if those are the most stringent identified measures possible at this point.
I think what I keep referring back to Rule 1402, but part of the reason that I do that is that Rule 1402 has a risk level set at 25 chances per million, that a facility is not allowed to operate above 25 chances per million after a certain time frame of chance to implement it. The level that we're sitting here in the stipulated order is about 100 chances per million, so higher than that. So we expect, as time moves on, this facility is part of the Rule 1402 process, that there will be more stringent measures that come along that are identified that we might not be able to identify today. But we are expecting more stringent ones to come along. And those more stringent ones, we might be able to identify those maybe even soon. But in the meantime, this threshold of 1 nanograms sort of puts a hard level on the facility to do what it takes to get up below that level.
Okay, and so just the question again, I assume you've reviewed the measures that are
Yes.
listed. And at this time, are they the most stringent that you are aware of?
After discussion with the facility, these look like these measures are addressing what appear to be the main sources of hexavalent chromium at the facility.
Okay, thank you.
You may continue with your review.
Okay. So I think we'll move on to paragraph 3. Paragraph 3 it puts a little bit more detail on how this curtailment would work. It requires that once the district notifies aircraft that there has been an exceedance, if we do record an exceedance, that we will notify them and that they have until midnight of that night or that day to cease their operations. After discussions with aircraft, and understanding a little bit more about their process, it sounds like it's not the kind of process that lends itself easily to just flipping a switch and just turn everything off, that there are many parts that if you, that take, in some instances, several hours to process, and that if stopping midway would maybe severely damage a part. And so what this paragraph does is it requires them to stop any new processes immediately or no later than midnight. And that if there are any processes that do require a few hours to finish their operations, they're allowed to finish that just on those parts, but they do also have to provide specifications, for example, that prove that they need to continue that operation upon request. What we have also heard from Aircraft is that that is not typical, that they have parts that take many, many, many hours to process. That is a small minority of their operation, but they would be able to answer questions on the details of that better.
Is this descriptive of the process that will be followed? I'm looking back at condition 1, where aircraft shall not operate any process or piece of equipment if the average of the air monitoring results exceeds 1.0.
Yes, this is just a further adding some detail to that same provision.
Okay, so that's how we should read this. We shouldn't read this as if they are still operating after the district determines that, or after there is an exceedance that is known of. We should look at condition number 3, because that explains how it will unfold.
Correct.
Okay.
Next paragraph.
Paragraph 4, it's fairly simple. They can start operating once the level at the monitor drops back down below the threshold of 1 nanograms, and we will notify them. And at that point, they could begin their operations again. I think that's fairly straightforward. We'll move on to paragraph 5, that they need to provide access to us for various sampling and monitoring, et cetera. Paragraph 6, that we are asking them to come back and submit a written report to us within a month that documents some of the housekeeping procedures, such as HEPA cleaning and wet cleaning in their buildings, so that we can see how that's coming along. Paragraph 7, similarly within 30 days. I'm
She
sorry.
has a question.
I'm sorry. It might be because it's late. I responded a little bit slower. Okay, within 30 days of the order to submit a written document, a written report documenting the completion of these procedures. These procedures are in the plan? Is that where the procedures are found?
No, so that they're laid out here specifically in the paragraph. These are also similar to what are found in paragraph 13 of the facts.
Okay. And in paragraph 13 of the facts, I flip to that real quick. Okay, I see. So this is just really an update to the district as to the completion of the items that you recommended as what they should be following.
Correct.
Okay, thank you.
Dr. Lerner?
Hi. I may have missed this. When the 3 samples are taken, how far apart? Days, hours?
They are currently taking a 24-hour sample once every 3 days. So 3 samples makes up about a week, right?
Okay, and what is the turnaround time after the last sample is collected to getting the data back?
Approximately 2 days.
So if it was done Monday, Wednesday, and Friday, Saturday and Sunday wouldn't count because they're not business days. When will they get the numbers back?
So, for example, a sample collected on Friday, the data would probably come back perhaps on the following Wednesday. That would be the longest turnaround. A sample collected on a Monday would probably get data back on, probably also on that Wednesday.
Okay.
So we do plan to continue to collect data over the weekends. We are not only planning to collect on business days.
Okay, so the turnaround time is approximately 2 days after the sample is collected, 2 business days.
Correct.
Okay. Is that standard in the industry for that particular measurement?
It's probably quick. Our district lab is probably at the forefront of how to do this kind of analysis, so it's pretty quick.
We understand the reputation of the business. My daughter in college has reminded me about it. She's an environmental policy major.
Oh, good for her.
Okay, Mr. McMillan, on page 10, line 5, there's some words missing from that sentence. Should it be aircraft shall provide?
Oh, at the beginning. Pardon me. Okay.
Then on same page, line 17, are we talking about a total enclosure for the grinding system, or?
I'm sorry, give me a second. So where it says aircraft shall upgrade the grinding enclosure collection system and add HEPA filtration.
Yes.
Yes, my understanding is that is supposed to be a total enclosure.
Okay, so those words, that word can be added. Mr. Taylor?
Yes, Mr. Chairman, we're okay with the addition of the word total before enclosure.
Thank you. Ms. Prusak?
I just wanted to point out, Chairman, as you did for paragraph 5, that the words aircraft shall is missing from a number of provisions, including 6 and 7, so they would have to be added.
Yes, you're right. That okay with the parties?
Yeah, that's no problem.
Shall we continue? Yeah. Any further questions? Apparently not.
Yeah, I'm sorry, could we get clarification? That was line 9 on page 10, total before enclosure? Was that what was suggested?
17
On page 10, it is on line 17. Aircraft shall upgrade the grinding total enclosure collection system.
And that's,
There's another one? Yes, right, thank you. On line 9.
May I, on that upgrade or that change for the upgrade on 17, just to be clear that the enclosure is not a total enclosure at this point, has not been certified as a total enclosure at this point. So when we're upgrading the grinding enclosure collection system, just to be clear, that has not yet been certified as a total enclosure. That makes it sound like it's something that's already been certified.
I see.
And I just don't want to mislead on that.
Okay, so the words have to be changed.
We anticipate it will be. It's been fully enclosed.
Okay.
But there's a certification process that has to be gone through and involve the air district.
Mr. Wong, can you offer some words to clarify that?
And Bill, would you like me to take a stab at that? Sure. Okay. What we could do is say aircraft shall upgrade the grinding enclosure to be a total enclosure, and let's see, upgrade the grinding enclosure collection system. Oh, there, okay. Aircraft shall upgrade the grinding enclosure collection system, new words, to be a total enclosure and add HEPA filtration. I think that would correctly do it.
In both places?
9, does that make sense?
And when you say both places, I'm sorry, we were talking in terms of line 18. It
Yes.
would go in between system and then there was another place.
I think
Line 9.
Doesn't make sense on 9?
Well, line 9 refers to the implementation of the cleaning procedures. So I believe that's different from the upgrade to the total enclosure.
Okay, so that upgrade to the total enclosure belongs in line 17.
Yeah, I think it actually goes in on line 18 right after the word system and before the word and, but 17 as it bleeds into 18.
Yeah, okay. Anything else, board members? Before, okay, how long? Oh, okay. We're off the record for a second. We're back on the record.
I'm going to attempt to say it. Okay. Paragraph 8, condition 8. It says aircraft shall expeditiously implement the measures. Paragraph 13. It's my understanding, based on what's stated in paragraph 13, that those are already in effect. Is that correct?
At this point in time, a number of the measures are in effect. Some are in the process of being placed into effect. Some of them are things, for example, that require air district permitting. So we weren't free to be able to take those measures right away. And so we're covered by some of these paragraphs here, such as the 30 days in paragraph 7. And others are training that, for example, that we're going through as the different shifts come into work and the training is being made. So there's some that are in progress, a few that are future, and quite a few that are already done. And we'll present some evidence in regards to that.
Okay, and the security or the hammer or what have you for the district to ensure it's just that the 1.0 nanograms cannot be exceeded. And so whether all of them are implemented now, some of them are implemented now, it's up to aircraft to make sure that that occurs.
I think it's worth noting that by responding to the LA Department of Public Health, per testimony yesterday by Dr. Rangan, we are committed to the county to implement all these measures before the board issues an order.
Ms. Byrd?
Can I ask, on page 3 of the findings and decisions, Exhibit 12, line 24, what that should be? No, it says November, and then there's a period.
Should be 17.
Thank you.
Where are you?
2016. Line 24 says sources of chromium 6 on November, period. Should be 17. Thank you.
November 17?
Yes.
2016. Okay.
I may be out of order, but there is an incomplete sentence on line 17 of that same page. Prevailing wind direction or rain on the day the measurement is taken and. Is there something else?
I think that should,
I think it's, the end is the extra word.
yeah, superfluous.
Thank you.
So we're taking out the word and placing a period after taken. Okay, I'm going to give the members of the public who wish to testify just a couple of minutes to testify, if you so wish. We need to close off for the day, hopefully make a decision. If not, we're going to come back tomorrow. Unfortunately, within a few minutes, I'm going to lose a quorum and can't do anything without a quorum. So is there any member of the public who wishes to testify? There appear to be none. Mr. Wong, you may make a closing statement. First of all, the provision that Mr. Tether did not want, would not agree to, is not here. I'm just verifying that.
My understanding is that they wish the order to be entered later.
Later, okay.
That's correct. Maybe they should speak to it.
That is correct. And that's also why I mentioned in response to a comment by Ms. Prusak that the 22 measures stated in paragraph 13 of the facts are already committed to. So these are going forward and will go forward. It isn't as though failure to issue an immediate order leaves us whistling a happy tune or something.
Okay. Ms. Prusik?
I was confused at the pre-hearing conference, and I remain confused. What are we being asked to do if it's not to enter an order? Why are we here right now? And how is this bifurcated if we cannot dispose of this case?
Actually, the district would. Ask for a brief recess. Oh, I've been asked to ask for a brief recess to discuss this matter with Kurt Weiss.
We're off the record.
Sure.
Oh, yeah.
Yeah, well,
Yeah, see you later. I'll get everything mixed up. There's an email regarding from Glassman.
No, he's over budget.
Back on the record, Mr. Wong.
Thank you, Mr. Camarena. We have conferred with counsel on the other side, and what we think is the most appropriate thing to do is to continue the hearing to tomorrow, because the issue of when it begins is somewhat complex, so we need to kind of work on that a little bit more and come back tomorrow.
Ms. Broussard.
Before we come back tomorrow, are we effectively being asked to do anything tomorrow? I'm.
Yes, I guess, yes.
Yes, what? If we're not being asked to enter an order, what are we being asked to do? Because I'm not sure why we were coming.
You will be entering an order, yes. We will be asking for the entry of an order.
This order?
I'm going to ask for this order, Yeah, so it's a little bit unclear whether it's exactly this order. So we will be discussing that. When it takes effect, I think that's the big issue that they're raising.
So if we issue the order tomorrow, it may not take effect tomorrow?
No, I think the order as written takes effect immediately. And what Aircraft is objecting to, that it essentially, if I understand it correctly, is they really don't want to have the order, they don't want their order to take effect before Anaplex. So that's something we have to resolve with them.
So the alternative, that is to enter the order at this time, would basically be punishing us for good actions, for getting in early, for not dragging our feet. The petition was served upon Aerocraft on November 29th. Aerocraft began discussions, and correct me, Mr. McMillan, if I'm wrong, on December 1st, and proceeded diligently toward this order. However, it certainly is difficult for Aerocraft. It's a difficult number anyway in terms of operation. It may be the appropriate number to protect the public health, and we respect that. But to leave us at the mercy of the emissions of a very nearby facility, emissions that are gaseous emissions and hence travel through the air further and more rapidly than particulate emissions, which are basically metals that come out one way or the other into the air and fall to Earth fairly close. To leave us at the mercy of that other plant, it doesn't seem fair. And that's why we want to not be subject to the order, except we're already bound and determined as well to implement as rapidly as possible the 22 measures that are set forth in paragraph 13. So we're not skating by any means. We're not trying to get out of ultimately being required to comply with the level that the district has found to be necessary to be protective of public health. But we want to be able to be assured that the enforcement of that level is on a fair basis and not at the fate of whatever might come out of a neighboring facility.
Ms. Byrd, then Ms. Broussard.
My question may go to you. If that's the case, this is a group OA, are we, if we don't issue an order for Aerocraft, because they want to wait for Anaplex, and there will be other DOEs, how does that work? Do we not issue an order?
I'm just trying to understand why we're coming in tomorrow if we've heard the order, but we're not being asked to enter it. I'm confused as to what our role is, and I'm not sure if anyone else understands what our role is.
It won't matter when we issue it unless it's about to be effective. So why rush to issue it?
Exactly.
What will happen tomorrow and the next day, if we issue it and it's not entered.
I mean,
Mr. Wong?
what does issue versus enter mean? Enter means issue. I'm confused.
Yeah, I think issue and enter is the same thing. So if the order is issued tomorrow, it's effective tomorrow.
We cannot make it. I recall in the distant past, we have adopted an order wherein certain aspects of the order are effective immediately, others at some later point in time. In fact, that's the way a lot of variances and orders for abatement go.
And we would be comfortable with entry of the full order with a delay on the entry of the 1.0 cap until such time that we have assurance that Anaplex will not be operating without any restriction and contributing to the 1.0 at our monitor. That's the fundamental concern. They're a couple hundred feet away from our monitor, and they're upwind of our monitor. And there have been days where it's been very clearly indicated that they're the dominant influence on our monitor. So the concern is if we're subject to an absolute closure that will go on for a week to 10 days for the facility, where it's not even clear that we're the one that is causing that influence in the monitor, you can understand that puts the company in a very difficult place. We're all for the protection of the community health, and that's why there is absolutely no issue with the entry of the order for all of those measures, the 22 measures. And we have a great degree of confidence that that will have a profound effect in terms of the potential for emissions from this facility.
Can we do that? Ms. Prusak?
Well, there's no stipulation from Aerocraft as to that particular condition. So, Mr. Wong, are you expecting that there's going to be a difference tomorrow morning in terms of agreement or stipulation by Aerocraft on that condition?
I believe there will be a difference. I think we're going to work with them on terms of trying to agree to some condition that would make it enterable by the hearing board.
And a question to Mr. Tether or Mr. Wood. I was thinking that you were asking this to be entered today because of the provision or the part of condition 1 that allows, if the off-site monitoring results are determined by the district not to have been caused by Aerocraft. That is not acceptable?
There is a great concern that at this point, while Anaplex is emitting at essentially full throttle, for lack of a better term, that'll be a very difficult determination to make. When both facilities are kept at low levels of emissions, it's a lot easier to separate out what the impacts are and make sure our hope is at that point that monitor is never over 1.0. I mean, that's really the goal for everybody, is that it's able to be kept below 1.0 and we're not having that concern. But if they're having a strong influence and they're emitting at 10, a couple of hundred feet away from where our monitor is, then there's a real concern in terms of what the impact is and is it possible to sort it out and keep this facility from being shut down during the time period that it takes to work out what is the influence from Anaplex.
Dr. Lerner?
Point of information, how many companies are similar to you and that are operating in the city of Paramount? How many other plating companies are there?
Well, first
Heat
is a...
treating companies.
Okay,
Yeah,
thank you.
Sorry. No,
Yes.
I'm lumping them all together because what I've read in the paper, actually what I heard on NPR driving home last night, there were 80 companies in the city of Paramount. 80 companies. So how are you going to ever sort anything out? You know, this becomes enormously difficult. I am just here because I want to hear all the information, but we have an enormous responsibility. The public is up in arms. They spent 11 minutes on National Public Radio last night discussing this. I was shocked driving on 60 going home last night at 5:30. to hear what is going on. The public outcry is enormous. I'm sure you guys are aware of it better than I because it's your career, your livelihood, your responsibility. But it's also our responsibility to protect the public. And I think if the good senator were here, he would lay it on the line to you even more heavily. I think your business is to try and do your very best. Well, I can't say what I think your business is. That's not, you have to make your own decision. But I understand your predicament. But it's not only the people that you just bifurcated from. Mm-hmm. There are 80 of such companies that are there. It's a difficult situation.
If I may, or go ahead.
I was just going to make the statement, only because I'm watching the clock here, excuse me, I had an appointment today. If we will be making an order tomorrow, have an effect tomorrow, I can be here tomorrow.
But only if.
I don't see any reason otherwise to be here.
And perhaps, well, I don't know that we can continue to tomorrow and then hear that we're not continuing to tomorrow, but I'd like to know before we come whether it makes sense.
Is there a way that if we reach a decision that basically, we're not involved in the hearing board, that we notify the hearing board members before they come? Is that something we could do?
We all have email addresses
Okay,
with the
so
district, so perhaps you could do that.
Okay, if that's not a problem, we could do that.
The clerk can provide that to you.
Okay, very good.
See any problem with that communication?
I go to bed Oh, because the clerk won't be in. You mean tonight is evening? You could send it to the clerk, and the clerk can alert us at 7 in the morning.
Okay. Okay, very good.
Thank you.
All right, then, we'll continue the matter to tomorrow at 9 a.m. unless we don't.
Notified otherwise.
Yeah. We do have a public document. This is an email from Lisa Lapine. It was sent Thursday, December 15, and it's date stamped December 15. It'll be marked as Public Exhibit 4. There's nothing else. This matter is continued to tomorrow at 9 a.m. And if there's no other business, we are adjourned. Thank you.
Thank you.
Alrighty. Looks like we're back to talking about